result of the COVID-19 pandemic and in accordance with the Governor's Emergency Order Number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing on Senate bills referred to this committee with the potential for executive sessions to be held throughout. Please note that there is no physical location for members of the public to observe and then listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of this committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Pro website. The notice of this meeting complies with House rules and RSA 91-A. Anyone who has a problem accessing this meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned or rescheduled. I will introduce the staff that are on the meeting assisting us. Brad Breeden, who's the committee researcher. Please note that all votes that are taken during this meeting shall be done by a roll call vote. Let's start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there's anyone in the room with you during this meeting, which is required and the right to know. And just the members understand, our clerk is not present today, so I will thank Representative Gaffney in advance. We will be acting as the clerk for the purposes of today's hearings. Clerk, will now call the roll.
Welch?
Yes.
Burke?
Yes.
Hopper?
Yes.
Green?
Yeah.
Thomas?
Present.
Estimate?
Here.
Short?
Present.
Pat?
Yeah.
Marston?
Present.
Nada. Sorry about that. Clerk is present. Pantelakis?
Present.
O'Hearn?
Present, home alone.
Bordenay?
Present, alone in the room.
Mills?
Here, alone in my home office.
Newman?
Here and alone in the room.
I'm present and I'm home alone.
Archiller? Get that correct.
Altschuler, yes, good morning. I'm present and I am in my home office alone.
Klein Knight? There.
I don't see him on the screen.
And Bradley?
Here and alone in my office.
And Pappas?
The chair is present.
So we have 20 in attendance.
And Representative Marcy, you're recognized to lead us in the Pledge of Allegiance.
Oh, first. Allegiance to the flag of the United States and to the republic which stands one nation under God, indivisible, with justice for all.
Chairman, before we open, if you don't mind, I see we do have some guests online. If you want to explain, like if we do any exec or, that they have to be on, the rules of the video.
So when the matter is put to question at that point in time, if a member is not in their seat, according to Rule 107, that member is not permitted to vote. For the members participating remotely, your device, the camera has to be on in order, when we're executing. So if your camera's not on when the matter is put to question, you will be considered to not be in your seat. I would say, for the point of transparency, while we're in an executive session, I would recommend that all members participating remotely keep their devices, the cameras on at that time. So that's a strict rule, and it will be strictly enforced, and it has been throughout this session. The other rule that I would just emphasize before we begin: if someone wishes to ask a question of someone testifying, we are not permitted to debate the witness. You're also not recognized to make a statement. If the member is recognized to ask a question, I expect it to be a question. If a statement is made and not a question, I will rule that member out of order. I assume we all understand that, so I think we can be in. At this time, we'll open the public hearing on Senate Bill 141, relative to the procedure for conducting a firearm background checks. The chair now recognize Senator Guida to introduce Senate Bill 141.
Thank you, Mr. Chairman, and distinguished members of the Criminal Justice and Public Safety Committee. For the record, I am State Senator Bob Guida. I reside in Warren. I represent 27 communities in District 2 of the New Hampshire Senate. I am the prime sponsor of Senate Bill 141, a bill that would authorize the FBI to conduct all criminal background checks for all firearms purchases in the state, as opposed to the current system whereby long guns are in fact directly NICS checked through the FBI, but any handgun is checked through the state police gun line. Historically, the state police gun line was established as an interim measure to enable the establishment of the NICS system pursuant to the Brady Act, and was never intended to be a permanent fixture in the regulation of the rights to purchase, own, and carry firearms. However, it has in fact transformed over the years into a permanent fixture. The purpose of this bill is simply this: it's to get rid of a system that is costing taxpayers extra dollars, and I can speak to that a little bit more later, that duplicates the FBI NICS system and is unnecessary, and which in fact has failed on numerous occasions, and in fact resulted in injuries by firearms to law enforcement officers and others. This is a system which currently operates in fact without statutory authority or agency rule. When one reads RSA 159, one finds that the gun line is only authorized to perform NICS checks. Over the years, the agency has in fact, the gun line has in fact expanded to check many things. Mine will speak to that a little bit more later. This bill has very strong support throughout the state. There will be testimony later on from firearms store owners and others who will share with you their stories and the inordinate delays that have taken place over the years, as well the fact that when the problem arises because of these inordinate delays, the gun line responds, and then a while later it falls back into its own ways. And those delays are an infringement on the Second Amendment. There are delays both in the purchasing of firearms initially and in the restoration of those firearms to individuals from whom they have been confiscated under domestic violence or stalking orders. I'm in receipt of a document which I believe each of you received from the combined offices of DOJ and Safety yesterday afternoon. That document is an affirmation of the activities of the gun line in testimony before the Senate. It was in fact stated that without authority, the gun line continues to operate, and that the gun line in fact exists in large part because the court system maintains a 170,000 name database, 170,000 records that are inaccurate and have never been disposed of and never received the proper disposition. So the gun line is actually in fact covering for the ineptitude of the court system to police its own records. That in and of itself should be concerning. The gun line gets removed, and in place we place the sheriffs as the performers of background checks with respect to the court-ordered interactions with gun owners. For example, domestic violence or stalking orders when guns are seized. And the bill provides funding for the sheriffs for 6 months and a 6-month gap between that funding and the actual disestablishment of the state police gun line to enable any administrative, operational, technical problems to be resolved. And the sheriffs have had concerns, as have the local police. We have addressed those concerns with amendments to the original bill, and those amendments are contained in the version that you have. That's the current amended version from the Senate. So the system will allow, in fact, will require the courts, instead of submitting domestic violence orders and releases therefrom and stalking orders and releases therefrom to the gun line, they will be directly sent to the gun line for forwarding to the NICS system so that they're in the NICS system very rapidly. Currently, there are delays in those records being forwarded, which of course puts at risk those who are the subjects of those protective orders. So what we do is we make the system much more streamlined, much less expensive, and much more in line with the constitutional freedoms. We do away with a system that is not authorized by statute or rule to operate currently in state government. And in so doing, we cause no harm, we increase no danger to those who may be threatened. We do, in fact, do a great service for those who practice the Second Amendment within our state. Let's speak for just a moment to costs. In this year's budget, the department has added 2 positions costing roughly $200,000 a year to the gun line. In addition, they pulled 8 troopers off the line to deal with the backlog at a cost of in excess of $200,000 in this present fiscal year. And again, I reiterate that the system is not even authorized to operate as it is under law. It is only authorized under 159 to perform the NICS checks as a point of contact defined under federal law. And so without further ado, I'm going to go ahead and accept any questions, Mr. Chairman, and thank you for the opportunity to testify.
Thank you, Senator, for your testimony. Representative True, you're recognized for a question.
Thank you, Mr. Chair. Thank you, Senator, for taking my question. So is that the cost of my question is the $400,000 the annual cost of the gun line?
I'm sorry, could you repeat the question?
It will cost of $200,000 for personnel, 8 troopers, and their hours of about $200,000.
Yeah, the state troopers was a one-time cost. They were brought in to do the background checks that weren't being done to catch up on this huge backlog. And I am fairly certain that they may have been released back to their original posts, but the department will probably can testify to that effect. The $200,000 a year will of course go up. Pay and benefits for 2 full-time clerks as well as those there currently. And here we grow government, not authorized by statute or a rule. in a system that has done background checks that are not authorized and far exceed any authorization under the NICS system. We repair we improve the delivery of court-ordered records, protective orders, to the NICS system so that it is basically instantly available within 24 hours for checking by anyone that might do a background check as an FFL, a federal firearms licensed dealer in the state. And so, again, we make the system much more efficient, much less expensive, and much more in line with the constitutional rights under ours and the federal constitutions.
Representative Tree, recognized for a follow-up question.
Thank you, Mr. Chair, and thank you again, Senator. I'm just trying to get a feel for what savings will we recognize if we do away with the gun law? So what?
Right, you're looking at $200,000 a year for the state police clerks. I'm not certain if any other personnel would be eliminated from their positions in that particular agency. That's a possibility. We do look at the possibility of costs to the sheriff's department, but as I said, we've provided $10,000 to each of the 10 sheriff's departments initially for startup costs in terms of equipment, the portals to the FBI, training for their personnel, and in the 6 months after that, we will find out exactly what other costs may be coming along. Again, the total number of checks that the sheriffs would do right now is between 450 and 500 a year. That's across all counties. And so there may be an adjustment of funding if necessary. But the time taken to do these NICS checks is very, very short under the federal system. And so I'm not certain that there would be any cost from the sheriffs, but we'll adjust to that as necessary.
Thank you.
Representative Pantelakis, did you have your hand up?
Yes, thank you, Mr. Chairman. Senator, I was curious to why you put it in the sheriff's hand.
Thank you for the question, Representative, and it's good to see you.
Thank you.
The sheriffs are located at the court system, basically. All right, and for that reason, in terms of efficiencies, when a court makes an adjudication, the sheriffs are on scene basically instantly once they get the record from the court, and they can go to work to process whatever it is that needs to be done.
Second question.
Representative, you're recognized for a follow-up question.
Thank you. Senator, is this going to bring any extra taxpayer money from the counties that take care of the sheriffs?
No, no, this should not bring any taxpayer money from the counties. It should not cost the counties any money. That's the way I should put it. And as I said, we'll figure out exactly what the time and cost constraints or costs may be, and I believe that the state would certainly cover that cost because it's part of our duties to do that. The
Thank
state court
you.
system, yeah.
Representative Muse, you're recognized for a question.
Thank you, and thank you, Senator, for taking my question. One of the things that I'm curious about is that as I read the bill, it doesn't look like the role of the Department of Safety is completely eliminated. So in the case of domestic violence protection orders, they appear to have a role if county officials can't, or the county sheriff will take longer than 24 hours to actually transmit domestic violence protection order information into the system. And it also says that, so the bottom line is there are several areas within the bill where the role of the state police and the Department of Safety appear to be preserved. So I guess my question is are we really eliminating all of these costs, and what exactly is getting eliminated, and why the decision to let some things remain with the Department of Safety, but to take other things away?
Before this hearing gets out of hand, Representative Muse. One question at a time for the witness. You will be recognized for a follow-up question. So just to make sure there's no confusion, there was 3 questions asked in that question. So just make sure the witness understands the questions. Let's keep it.
Thank you.
All right.
I'm going to try to address them as I remember them. The first question, yes, there is a role for the state police, and it is to take the domestic violence orders, okay, and insert them into NICS if the court has not. And there, again, I think there'll be personnel that follow on that have a better understanding of that process, because the intricacies of it are substantial at present. But right now, the state police would be recipients of domestic orders and put them into the state police and into the NICS system in West Virginia.
Representative Muse, you recognized for a follow-up.
Well, I'm just curious why that would even be necessary if the county officials are doing what they're supposed to be doing under the way that the bill is written. Why do you need the state police to serve as a backup?
I wouldn't know. I wouldn't need it. I would say that, if you think there's a way that we can eliminate that, I'm certainly amenable to that. I think, again, it would provide a central database for all domestic violence and orders in the state. And we don't have that at present. It certainly would not be the intent of this bill to allow them to pursue any other investigative capacity, but it would serve as a repository for all domestic and stalking orders in the state. My understanding is that that doesn't currently exist, that they're, and I could be wrong, but I think they're maintained at the respective county levels. So that would be one benefit of that. But I'll let subsequent testimony address that issue.
Thank you.
Representative Alshaw, you're recognized for a question.
Good morning. Thank you, Mr. Chairman. Thank you, Senator, for taking my question. So I'm actually on page 1 of your bill, and I'm looking at line 8 under findings. And my question is, you have in your preamble here on part 2, the gun lines inefficiencies have created significant delays. And I'm curious, and could you please define what that means? What is a significant delay, and how that made it into the writing of this bill? And is that the problem this bill is solving?
Thank you, Representative, for your question. That was the origin of the request from many people to write this legislation. There were many times where the initial purchase would wait days, which in and of itself creates a threat. And I think further testimony by subsequent witnesses will attest to this. But it created really inordinate delays in the domestic violence and stalking order return of weapons as long as a year. People would put in the required paperwork, and it would take as much as a year. I'm led to believe that the improvements instituted by the department subsequent to the introduction of this legislation has significantly reduced those times. Again, though, at additional cost and beyond the scope of any statute or rule that authorizes them to do so.
May I follow up, Mr. Chair?
Representative Alshaw, you're recognized for a follow-up question.
Thank you very much, Mr. Chair. Thank you, Senator Gaida. I appreciate your response to the last question. And now I want to switch gears a little bit. And I'm going to line 22 on page 1, which I believe references close to the references the fiscal note on page 5. So on line 22, it says this bill saves tax dollars. And from the outset, from where I'm sitting, and I'm actually interestingly enough, just got my Rockingham County budget in my hand. It arrived the other day. And after having read this legislation, it appears, and perhaps you can correct me as to how I'm maybe not understanding your intent, but it looks like the downshifting of this responsibility out of the Department of Safety, which would be a state responsibility, down to the sheriff's departments, which would then be county responsibilities.
Sheila, is this a question? Or is there a question coming?
Yes, sir. Yes, sir. So in your testimony to, I believe, Representative Muse, you had said that there may or may not be more money for counties coming out of the state budget, and have the county sheriffs embraced this downshifting of responsibility to the county?
Is there a question coming?
I just asked that question.
Okay, so as to the downshifting, as I said, we have an initial outlay of $10,000 per county to get the system up and running, and any administrative costs related thereto, personnel training and so forth. Subsequent costs, I have told the sheriffs that I will pursue, and I'm sure that the state will fund any additional costs, bearing in mind that the costs of doing a NICS check are negligible in terms of time. It might take 3 minutes, 4 minutes, and even if you equate that, those are costs that are manageable. So any cost downshifting to the sheriffs will be funded by the state, as I think they must. It's a state court system that makes these adjudications that require this work by the sheriffs. And so for that reason, I believe the state has the obligation to pay for those.
Representative Perry, you're recognized for a question.
Thank you, Mr. Chairman, and thank you, Senator, for taking my question. Currently, all long guns go through NICS from the dealer, and all handguns go through the New Hampshire State Police. But can you also explain that bottom line, the New Hampshire State Police goes to NICS? So they're more or less a middleman?
Is that a question?
Yeah, the system is such, the NICS system allows the establishment of point of contact. A point of contact is a law enforcement agency that's authorized to conduct the NICS checks, okay, as an interface. Many states are purely directly from the purchase point to NICS. Some states have points of contact. And in our state statute, you find that the point of contact legislation, law in 159 only authorizes the department to do NICS checks, all right? And that NICS system queries three different databases for potential violations that would disqualify a purchaser. So, the state police do the NICS check, and then they do other checks that are not authorized in statute. In fact, they'd really gotten out of line, and we're in fact going back to states of residence and states of birth of people way outside the scope of anything that's rational. And so that's another reason that we decided to put this legislation in, to bring them into conformity with the existing law that only authorizes the state police to do NICS checks.
Follow-up.
Representative Perry, you're recognized for a follow-up question.
Thank you, Mr. Chairman. Senator, bottom line, can New Hampshire, let's say NICS got shut down, can New Hampshire do their own background checks without NICS?
The answer is a categoric no. And in fact, in the legislation currently under consideration at the federal Congress, there's an extension up to 10 days before, of a delay It had been suggested by some that that doesn't apply to the state police gun line. That's categorically false. The state police gun line as a point of contact is subject to exactly the same rules and regulations and delays as a firearms dealer. So there's no special category, no special lines, no special anything. They are subject to exactly the same laws. And that's not me, that's the Congressional Research Service that opined on that legislation.
Thank you.
Thank you, Senator, for your testimony. The chair would like to inquire, or ask a question, and I want to thank you in advance for taking my question. Can you describe, in your opinion at least, what is causing some of these delays? Because in my own personal life, I never experienced it. So I've heard the stories. What is causing these delays?
I would suggest that in one case, well, in numerous cases, the large volume of checks that needed to be done. I think certainly the outreach by the department into areas not authorized by statute or rule in checking things. And a large part of that is again, the 170,000 records that have not been achieved disposition by the Department of Justice. So again, a little house cleaning wouldn't hurt there. So volume of sales, the overreach by the department beyond its statutory authority, and personnel shortage, I think, are probably the prime drivers.
Thank you. Representative Pantelakis, you're recognized for a question.
Muted.
Representative Pantelakis, you need to unmute.
Thank you, Senator, for taking my question. I'm just wondering how many people will be needed to be hired at the Sheriff's Department to implement this?
My answer to that would be none. The volume of cases that they would deal with, I said, is 450 roughly a year. That from the Justice Department's own numbers. And if you look at that, and if you divided it out either on the basis of population or otherwise, to do the NICS check or the research might take an hour. It can be done by anyone that's authorized by law to do those checks. It could be someone that's required to be deputized. It could be a dispatcher at 11 o'clock at night. There should be no additional personnel requirements. The system is very quick. The system is very easy to use. It's a direct portal into the NICS system and very simple to operate. We will, of course, pay for the training of the individuals that will operate it.
Thank you.
Representative Newman, you are recognized for a question.
Thank you, Mr. Chair, and thank you, Senator, for taking my question. Could you just elaborate on, my understanding is that the handguns use the FBI NISC, is that correct? And then we use the gun line for long guns?
No, sir. I think that's in reverse. A person that purchases a long gun, the FFL, the dealer, directly queries the NICS system. But the state police gun line is only for handguns. And that, again, it begs the question, if a person wanted to do harm, was not authorized to buy a handgun because of the checks done by the state police, they would still be authorized to purchase a long gun. And so that begs the question, are we really doing anything for the safety of individuals with this? If we made it through the FBI directly and submitted all the court orders and so forth there, both long guns and handguns, as in many other states, would trigger the disqualifier. And the administrative process much quicker, the same information in there much more quickly, and again, to the benefit of both the consumers and, of course, the dealers, and I think the safety of the people of the state.
Representative Newman.
Follow up.
Representative Newman, you're recognized for a follow-up question.
Thank you very much. So just for further elaboration, why don't we just use the NIST system for both?
That's exactly what we're trying to do here, sir.
Okay. Thank you.
Representative Alshaw, you recognized for a question?
Thank you, Mr. Chair, and thank you, Senator, for indulging me in another question. You mentioned in your testimony that the state is conducting through the gun line 450 to 500 inquiries per year. And so we know that that can't possibly shake out to the counties with an equal distribution. Do you have information as to which counties receive more and what the inquiries are per county?
All right, look, thank you for the question, Representative. I need to clarify that the court involved cases are 450, 500 a year. Obviously, many more total across the state in terms of purchases of firearms overall. And so it's as a sure bet that it's not a linear distribution. It's not equally against the counties. And so, but it's also, again, counties generally have more staff if they're bigger and more population. And again, the amount of time to conduct these checks within the confines of current statute is very limited. It's very minimal. And that would, again, I don't think it would certainly exceed anything that the state should and would, I believe, pay for.
Follow up, Mr. Chair.
Are you recognized for a follow-up question?
Thank you very much. And thank you for taking this follow-up question. So I'm going to ask this through the lens of somebody who lives in one of the more populated counties here in the state. I live in Rockingham County, and it would seem that based on population, that if that my county and perhaps Merrimack County, another very populated county, would perhaps be processing, or their sheriff's department might have to process a whole lot more of these checks than, say, a less populated county. And so that distribution of funding that's in the bill in part on page 4, lines 21 through 26, it looks like the distribution is equal, but there isn't anything in that space. And would you consider putting into that space a state commitment to covering that cost rather than making these counties come back to the state on an annual basis, or I'm sorry, biannual basis for the biennial budget, so that those costs don't shift down to the counties? Because right now it looks like once the training is over, if I read this correctly, once this training is over and setup is done on lines 21, 22, and 23, then all state money seems to go away. So would you be interested in adding in a state budget for this so that counties can meet that demand?
I would certainly entertain that, Representative. It's an excellent question. Again, that 10,000 per county is the initial training, equipping, and so forth. And the bill does not address beyond that. I'd be happy to do so. I think it'd be important to reassure counties. Again, it may need adjustment. I'm not sure we come up with a figure, and that was one of the reasons we wanted to have that 6-month window between getting the funding to set the system up and actually switching over to it, to try to figure out exactly what those costs would be, and then to bring them in. And I'd be happy to entertain language to do that. I certainly think it's the state's obligation.
May I follow up, Mr. Chair?
You recognize for the last follow-up question.
Thank you. And thank you for taking my last question. So if you turn, just so the other members of the committee know where I am on page 5 on the fiscal note, and there's other than the money that's laid out on page 4 as startup costs, which are equitably distributed through the counties, there's nothing in the fiscal note, and I'm concerned. And I think one other thing that's, did you mean to do this? Was there's no projection of how much staff would need to be instituted by county to make this work, and also support systems throughout those 6 months, or is the support supposed to be in that 10 grand?
I think I know what the question is, but let me, the 10,000 is basically the cost of setting up the system in each of the counties. Okay. And that includes computer terminal if necessary. I don't believe the FBI charges for access to the portal. It'd be a secure portal, and the training required as to how to use the NICS system. And so that 10,000 is in the bill per county. I'm not sure what the fiscal note is addressing here. It does, in fact, if you read at the bottom, it abolishes the state police gun line. Again, I'm not sure what the exact metrics of your question are, but it would save a considerable amount of money, and as well as the 2 additional staff that were going to be added in this year's budget at a tune of about $180,000. So you're going to save close to $500,000 a year. That money, I'm sure, would more than cover the costs to all the sheriff's departments. Remember, given that they're going to be doing the NICS checks, and they'll be researching the domestic violence orders, which will now be directed straight into NICS and also to the Department of Safety. And referencing Representative Muse's question, of course, that may even further streamline the process. But I think further testimony subsequent to mine will more appropriately address those intricacies regarding that. Have I answered your question?
Almost. May the record reflect Representative Klein Knight is going to join the meeting, and I just noticed it, and she also has a hand up. So Representative Klein Knight, you are also recognized to ask questions.
Thank you, Chairman. Thank you, Senator, for taking my question. So this completely, am I to understand, this basically bypasses the FBI need for us to use them, and we handle everything at the county level?
No, thank you for the question. It is not lawfully possible to bypass the FBI NICS system for the purchase of any firearm in the country. What this bill does is it takes from the state police gun line, okay, the processing of checks into domestic violence and stalking orders, gives that to the sheriffs because they're co-located with the courts, and it then directs the court system to directly input to the FBI. Parenthetically, we have checked the FBI is capable and ready to accept those records, any domestic violence or stalking orders, into the NICS system. All right, so we stop any delays at the state police, and we go direct from the court straight into NICS. The sheriffs, when these court orders regarding domestic violence and stalking are rescinded, then the sheriff goes into NICS, looks and sees it's been rescinded, because without that creates the delay that's been prevalent in the state police records through the gun line. So again, it streamlines the process and requires and provides the NICS system with the information it needs that it's not currently getting because it's going to the state police gun line.
Representative Klein, do you have a follow-up question?
Yes, thank you, Chair. Thank you, Senator. So it's getting a little clearer. So we want people to be able to protect themselves, and I agree with that. So this streamlines the process for less waiting periods. Do you have any data on how many incidents there were for people that actually waited before this was enacted as our current law exists? Is there any incidents that come to mind? Is the reason why we need to put this bill forth? Do you have any data on that? Any numbers of what's going on in the state?
I think subsequent testimony will provide that, but I can tell you it's in the hundreds, if not the thousands, of delays that have been caused over the last several years.
I'm sorry to interrupt. I don't mean delays. I mean victims that have fallen prey because of a delay. Do you have any incidents where there was a crime because of this?
I can specify, I know of one specific one. That was 2 Manchester police officers that were shot not too long ago by a person who escaped, if you will, the scrutiny of the state police gun line. I think subsequent testimony will attest, to more specific incidents that have happened. Again, of concern is the situation where, because of the delay, the individual can procure a weapon after 3 days under federal law, and that particular weapon for which they applied for the NICS check. It puts the gun dealers in a terrible position. And so, again, if we take the gun line away, we leave the sheriffs there to deal with the domestic violence piece, and all firearms purchases go directly to NICS. We stop a lot of these delays that were caused with the short stop at the gun line before things got down to the FBI, before the weapon was actually delivered.
Chair recognizes Representative O'Hearn for a question.
Thank you, Mr. Chair, and thank you, Senator, for taking my question. And I may have a follow-up, but my first question is, you stated that the Sheriff's Department is at the courts and that they would work hand in hand together. But it is my understanding that the Sheriff's Departments are only at the Superior Court level, and on the Circuit Court level, the bailiffs are through the other security system through the state. So I see a potential problem with that.
Well, I would offer that if the court puts the records into the NICS system, all right, electronically, immediately upon the issuance, or within 24 hours of the issuance of the domestic violence or stalking order, that information is available to the sheriffs wherever they're located. All right. So I'm not sure that the geographic location together with the courts is really a factor here. But the point being that the courts would directly input the stuff into NICS, and it would be instantly accessible to any FFL dealer, to the sheriffs, to anybody that was then to query the system, regardless of location. Yeah.
Follow up.
O'Hearn, you recognized for a follow-up question.
So, in the beginning of this, your statement, or if I recall, you said that that the state police don't have the authority, and that this is going to clean it up so that we downshift it to the sheriffs. But wouldn't it have been much easier to just propose something that corrects the problem on the state level instead of downshifting it to the county level?
I think for the sake of efficiency, the gun line is going to is cost already. It's $500,000 a year, and I just think that things are handled better locally, close to the courts, and that's just, I suppose, my position. Again, as to the downshifting, the term, again, we're covering the costs of implementation. We have 6 months to study what other costs might be incurred over the operational lifetime, once we get into using the system at the sheriff's level. And those costs, as I've said, I'm more than happy to entertain an amendment as suggested by Representative Altshuler to address those issues going forward. We're trying to get a handle on if those costs would exist and what they would be, and that's another reason for that 6-month delay.
Representative Green, you recognize for a question.
Yes, thank you, Mr. Chair. Thank you, Senator, for taking my question. Several years back,
there was a gun dealer on 125 in Brentwood. He was a single person in the store. 3 gentlemen came in to purchase a handgun. They did the background check through the state police, and the guys were getting very impatient. But about 25, 30 minutes later, 3 state police showed up, 3 state cruisers showed up and arrested these guys. There was a warrant out for them. And when they were being arrested, they threatened the gun dealer. And 2 weeks later, the gun dealer closed his shop, and that was it. Would you believe that by going with the NICS, is this going to be as effective?
I absolutely do. Absolutely do. I think it would be better. Again, for the reasons stated, it would be much streamlined. And if a NICS alert goes out, the NICS alert goes out. The state police would be notified. I think potentially and respond as quickly. You know, I don't see that as a problem.
Okay, thank you for taking my question. Representative Muse, you're recognized for a question.
Thank you for taking another question from me, Senator. One of the things that's baked into the bill is the assumption that the courts can directly input domestic violence protection order information. My understanding from some bills that we heard testimony on in the last session is that the state actually provides and submits protection order information into a different database than NICS. So it's actually submitted into the National Crime Information Center, NCIC database through SPOTS, the state police online telecommunication system. My question is if the state police are not involved in this process, and this is something the courts are going to be doing directly, would the courts have access to a system like that, and how would this work?
The NICS system checks 3 things, and one's III, I forget the second, and the third is NCIC that you mentioned. Again, that's more of an electronics question as to which database the court's documents go into. As long as they're submitted directly and timely, the NICS system will check that database. I said NCIC is one of them that is checked, National Crime Information Center. And so I don't think that's a problem. I think it's a matter of electronics as to which database the information. It's currently going from the state police there. If we take the state police out, we just send it directly there from the court system. A little bit quicker, perhaps.
Representative Meach, you recognized for a final question.
My follow-up question would be is if that's something that doesn't exist now, isn't that the kind of thing that would actually add to the implementation cost of a system like this? And given the level of security that would be necessary for something like that, wouldn't that be a fairly significant cost?
I don't think so. I think it's a computer terminal. The portal into whichever system it is, I think it might be III or whichever, NCIC. I don't see a cost there that's of any substantial nature. I said we're already doing it through the state police. It's just a matter of switching the recipient. Instead of sending the information to the state police to send in, we send it directly to that very database.
Thank you.
132. Seeing no further hands raised, I want to thank the senator for his testimony.
Thank you, Mr. Chairman, members of the committee. I appreciate your consideration of this legislation. Thank you.
And just to clarify before we call the next witness, we're going to limit testimony to 3 minutes per witness. Also, and we've been following this throughout the hearings, that each member is limited to 2 questions per witness. I did allow an exception for obviously the senator who introduced the bill, and I allowed an exception for the questions as well. But going forward, there will be 2 per witness.
Mr. Chairman, could I make a point of order?
You don't have to ask to make a point of order.
All right, point of order.
Point of order it is.
Thank you, Mr. Chairman. On this particular topic, we got 2.5 hours to have a debate, and I see some hands up, to Steve. I would just hate to limit to 3 minutes when key people chime in, because they're gonna have a lot of good information. And then to limit us just to 2 questions, you know.
It is discretionary. My
It is.
understanding is that it's both the restriction on the amount of questions and the time limit for witnesses is within the discretion of the chair. For the people who've been following along often see that I would you allow 10-second, 15-second leeway with that. And it's at the discretion of the chair. At one point, we limited a witness to 1 minute, and I did allow her to go on for 7 minutes, given the weight and subject matter for testimony. That was in a different hearing. We won't get into. So it is within the discretion of the chair. So I understand your point of order, but the goal is to keep the hearing going. We have a lot of witnesses present. We have people who work for the state that are present. We have members of the public present. We want to make sure that people who are on tight schedules are actually able to testify. If we have additional time, we'll take that into consideration as well.
All right.
We got a fiscal note on that though. So, have to look at it.
The clerk has brought to my attention that there's a new fiscal note for the bill that is apparently inside our email. That was sent to us at
9:32.
9:32 this morning, 9:32 a.m. So
Bradley.
By who?
Bradley Green.
Who?
Bradley Green.
Who sent it?
the committee research.
Oh, okay.
At this time, the chair recognizes Commissioner Robert Quinn.
Good morning, Mr. Chair. Can you hear me?
Yes, Commissioner, we can hear you.
Yes, thank you. Good morning, everyone. I just wanted to clarify. My name is Robert Quinn. I am the Commissioner of the Department of Safety. Present in my office is also Lieutenant Michael McQuaid, who oversees the Permits and Licensing Unit, currently referred to as the Gun Line. As you've heard in prior testimony, we have been addressing a rather large increase in requests for purchases. We have done quite a bit over the last several months. I also wanted to say we have partnered with the courts, and I believe Attorney Richard Head is also on the line. Our Permits and Licensing Unit have worked closely with the courts. As you heard prior testimony, we've heard about protective orders and domestic violence orders. Some orders that can be entered into NCIC, some orders that cannot. You've heard about different systems here, federal systems, state systems, databases, where this is such an important issue and a rather complicated issue. We provided, and I know the courts provided, a fact sheet, and I just wanted to ask the chair, sir, to you and the members of the committee, have you received what was the work that was done by the courts and the Permits and Licensing Unit? Representative Abbas, I just wanted to confirm that you did have the material.
You got it yesterday, I think.
Is that printed out for the members in the room?
Looks like enough.
We do have, the members participating remotely have the materials.
It was emailed to us late yesterday.
Okay.
Okay, thank you. And I don't want to speak for Attorney Head. I know he's also present on the call. I just what I wanted to do was ensure that, and I think that this work product clearly lays out the background, the differences between the search that's conducted by the FBI and the Permits and Licensing Unit, also addresses the return of the firearms, which has been discussed earlier, and the process and the difference in the process and what we have done to streamline or improve the efficiency. And that is, we've redefined the scope of the checks and we've aligned it more. But I think it's important to understand the difference between the databases so that everybody is clear. What is NICS? What is NCIC? What is contained in the NICS index? And what does the Permits and Licensing Unit do? And currently, the Permits and Licensing Unit also includes the licensure of security guards, explosives, and private investigators. So this Permits and Licensing Unit, where the gun line duties exist, have other collateral duties. But I would, I don't want to go through this line by line, but I think it's important for the committee to make sure that everybody understands clearly what the differences is and how some of these protective orders may be entered into NCIC or may not. And those that are not rest solely in the Permits and Licensing Unit for query and cross-check. So I would, again, for time, I would like to, again, I've got Lieutenant McQuaid here, and I would like the courts to be able to speak more specifically to their process and how the protective orders travel from, you know, from a victim to the courts, you know, what gets entered into NCIC and what doesn't. And again, just as a little history, which is contained in it, we've been handling this at Department of Safety since 1993. So Representative Abbas, I would avail myself to any questions on any of the content that is contained within this 8-page document. And I want to thank Attorney Head for partnering up with Lieutenant McQuaid and putting this together. So I open to any questions that you may have. And again, I'm joined by Lieutenant McQuaid, who might step in as well. Thank you, sir.
Thank you, Commissioner, for your testimony. And the chair would inquire of a question of the witness. I want to thank you in advance for taking my question. If you heard testimony from the senator who introduced the bill, he spoke about these a series of delays that people were having that were delaying the process. Do you have any explanation for what is causing the delays?
Oh, absolutely. So he is correct. There were delays. And I think that we had over a 60% increase in gun sales. That coupled with during COVID, we had some employees that were out impacted by COVID. So you had approximately 65% increase in volume. But more importantly, we had a process. The statute doesn't define exactly what the check is that is done by the Permits and Licensing Unit. So we worked closely with the Attorney General's office and we redefined the scope. What is the check that the Permits and Licensing Unit will do? And we redefined it and we brought it back. So we believe it is in the best interest of public safety. And it was, you know, looking further into our own criminal records repository to ensure that there were not disqualifiers that had not get uploaded into the NICS index, but balancing the right of somebody to purchase a firearm. And some of these delays were, you know, were unacceptable. So I think what we did is we redefined the scope of the check, which I think was very important. We looked at our phone system, which we've readdressed in the past several months. We've looked at, you know, the technology potential for improvements on some of these databases. But I think the key is we have been able to keep these backlogs down. I think they are in a good position right now. We address the backlogs in the court. So to answer your question, sir, it was a over 65% increase in call volume. It was essentially a perfect storm. And we dealt with some vacancies due to COVID, and also, again, the scope of the check. It was, in my opinion, too expansive. We redefined it. We're looking at our own state records. We're querying against the list that we get from the AOC daily on any protective order where the victim does not have a date of birth. We query that, look at our own state, and then align with the FBI. The other issue is we had many cases that were in delay status, and sometimes it can go into delay because of this. An example is somebody wants to purchase a firearm. The permits and licensing unit clerk looks at the record. The record on its face is incomplete. There isn't enough information in there to determine is that a disqualifier? Is that a disqualifier? What actually happened in the court? What was the final adjudication? What is the potential sentence? So they have to reach outside of the state. They maybe have to look towards another state. And quite honestly, many states just aren't responsive in time. And we're supposed to have these, if it's in delayed, get it to denied or approved within 3 business days. So what we did, we had many that were far beyond the FBI limit of, I believe it's 88 days. And so what we did was we brought ours back after 88 days. If we can't get an answer, then we take it out of that delayed status. So to address, we've looked at our process, we looked at our personnel, we looked at cross-training, we've looked at our phone system, and we redefined the scope of our stop, of our background check to ensure that we're balancing the right to purchase a firearm with doing as safe as reasonable background check. Understanding we could not call all 50 states to ensure that there is not a disposition or a conviction that hasn't been uploaded. And just to be clear for everybody, this is very complicated, but in the III database, what we refer to as the FBI check, if there is a conviction in any state where the defendant was not fingerprinted, that would not be in that database. So, so I hope that answered that question, sir.
Thank you, Commissioner, and thank you again for taking my question. The chair recognizes Representative Buse for a question.
Yes, thank you, Commissioner, for taking my question. My question is around any inconsistencies that you might see as you look at the bill and as you read it, and the way that you understand that the process not only is working now, but would have to work if it's changed the way that it's specified in this bill. So do you see things that, based on your knowledge of the way the system works, the way the FBI works, that could be problematic?
Well, I mean, in the simplest terms is this. If you purchase a lawn gun today in New Hampshire, it goes to the FBI and they run it through their next check. That, we are, I believe, one of 3 states. If you purchase a handgun, if you were to send it to the FBI, to keep it as simple as possible, if you look at our fact check here, there are several steps that would not be checked, that would be missed. And I think that is something that is just, that is accurate. We're doing above and beyond some steps that they would do. And I go back to that list of, I believe it's roughly 50 to 70 that file a protective order for whatever reason, and we get that emailed. So we cross-check against that prior to approving on any purchase. So I would say, to the return of firearms, we do the return of firearms with these that have been taken through the courts. And sometimes the local police departments, if they seize a weapon, whether it's from a burglary or whatever reason, they can run that NICS check as well to see if the weapon can be returned. But again, when we do that process through the courts, we also query against the list that we're getting that's unsupported by a date of birth. So I would say, Representative Muse, we have done, and we do more than the FBI. We were doing several additional steps, but as I said, as our policy, we redefined it. We brought it in because it was just not sustainable, and so we had to balance it. So, and again, that's contained in this document in more detail.
Thank you.
Representative Muse, you have a follow-up question? Chair recognizes Representative Marston for a question.
Thank you, Mr. Chairman, and thank you, Commissioner, and the other gentleman that's with you. I would like to know, are you in favor of this bill or opposed to this bill?
We're remaining neutral, Representative Welch. And what I mean by that, I believe this is a policy decision. And what I've said is this: if the gun line is to stay within the Department of Safety and the Permits and Licensing Unit, we will do the best we can to ensure customer service is met, public safety, and we do the best job we can. If the decision is made to send this to the FBI, then I believe that's rests in your hands. So we're remaining neutral on it.
Representative Marston, you recognized for a follow-up question.
Thank you, Mr. Chairman. Thank you, Commissioner, and you people on the other end of this. I cannot remain neutral. I have to take a vote. A vote means I gotta go up or down. And I'm saying to you, give me a vote, up or down, with the bill or against the bill. Don't give me neutral.
And before,
Point of order, Mr. Chairman, this witness is not an elected official to vote and give a decision to Representative Marston, which he was elected to do.
First of all, Representative Klein, I believe I recognize your voice, but your point of order is made. I heard your point of order. The representative asked a question of the witness whether they oppose a bill or they support a bill. The witness has the right to answer the question saying that they are neutral. With that being said, it's quite often that when any witness testifies before, I believe this is actually the policy of every committee, that the witness states their position, whether it's in support, opposition, or neutral. So your point of order was recognized, and that's the ruling of the chair. So the question is appropriate. I also believe that that question was asked and answered already, but if the commission wishes to clarify, he may.
I stand to my answer. We remain neutral.
Representative Newman, you're recognized for a question.
Was that for me, Mr. Chair? You were a little garbled.
You are the only Representative Newman on the committee. You're recognized for a question.
Thank you. And thank you, Commissioner, for taking my question.
Yes, sir.
This is a complicated issue, and there seems to be that the gun line did a lot of extra things to check the extra databases that we have information on. And in your reading of this bill, do you see that type of ability to do that kind of thing when it's transmitted to the counties, that the experience the gun line has had with that kind of stuff will be adequately trained to the people at the county level?
Well, I think here's a point of clarification. The county level will not be making these decisions. This will go to the FBI, NICS. They will make the decision, and those additional checks will not be made.
Thank you for that answer.
Representative Alshaw, you're recognized for a question.
Thank you, Mr. Chair, and thank you, Commissioner Quinn. You mentioned in your testimony that New Hampshire has seen a 60% increase in gun sales. Is that in this past calendar year, or what was the time frame that you're referencing there?
So we did, ma'am, and again, just give or take several, I believe it was 57,000 in 2019, 87,000 in 2020, and we are currently in the area of 30,000 with 4 months. So we estimate an increase in 21 from 20. So that was from 19 to 20, which was the over 60%, approximately 63, 65% increase. Those are the years.
May I follow up, Mr. Chair?
Representative Alshaw, you're recognized for a follow-up question.
Thank you very much. Thank you, Commissioner. So in this, and we can, I would appreciate an answer in either the 2021 range or the 2020 range, whatever information you have. But the concern for this bill seems to be that people are not able to access a purchase of a firearm. And so my question is, with this increase in sales, how many of these people are first-time gun owners?
We would not have that information. We don't, and by statute, we're not allowed to retain that information.
Mm-hmm.
It's 63%, which is, these numbers are on page six of the the document we've provided.
Okay, I appreciate that. I don't have that document. That was not sent to me. So did you, I'm sorry, 63% increase, not 60? Did I hear you wrong?
Yes, with over 8, yeah. So both in 19 and 20, the gun line realized significant increases in the number of queries that were received from the over 400 FFLs throughout the state, with over 86,000 checks being processed in 2020, which represented a 63% increase from 2019.
I have a follow-up, Mr. Chair.
We are limiting questions to two questions per member. Representative Welch, you are recognized for a question.
Yes, Commissioner, would you agree that the gun line has experienced problems, and have those problems been addressed?
Yes, I would agree that the gun line had significant delays, and we have addressed them. And I believe today we are in a better position, stable. We're looking at the metrics, times, frequency of calls, staffing, call taking, and scope of the checks. So, and I would give the credit to Lieutenant McQuaid and his team. And again, we've partnered very closely with the courts to ensure that there's synergy there between us and the receipt of information that we need to make these decisions. So yes, I will, absolutely, there were delays. But again, I go back to, we had a 63% increase in volume, and we were also dealt internally with some issues due to COVID. But it's in a much more stable position today, and I think we have a plan moving forward.
Representative Welch, you are recognized for a follow-up question.
Yes. What is your plan for the immediate future?
I'm sorry, sir. Could you repeat that?
What is your plan for the immediate future for improving the gun line?
Sure. Thank you for the question. Well, in this budget, we have requested 3 additional positions. The plan is to get these troopers, back to what their jobs, which, we understand that, recognize that, and looking at potential technology options, the phone system, the aligning more with the FBI. I mean, quite honestly, the scope of our search was too expansive. And that really, I would say, increased our delays. So I think that was probably the most significant step to address the gun line that hadn't been taken in years. And I credit the Attorney General at the time for working on that with us. So I think we have a good check in place. We're looking at, we know when the shows are, we know the busier time, the peak times, we're tracking that, the metrics. And I think the call system, being able to put, taking 400 calls and getting them in a queue as opposed to, 5. So, we've really looked close at the customer service and process improvement, and it's continuous process improvement, sir. So I hope I answered that.
Thank you very much.
Representative Klein Knight, you're recognized for a question.
Thank you, Chairman, and thank you, Commissioner, for taking my question. My question is, even with any kind of delay in processing paperwork, doesn't page 2, lines 8 through 10 ensure anyone in any county can buy a gun without any sort of background check? And I have a follow-up after that, if you can answer that, please.
I don't have the bill, and so are you talking about could you just be a little more specific with what those lines are? Because I don't have that on my screen. I'm looking at our fact
We
sheet.
need 2 lines 8 through 10.
And if I can just have a minute, I'm trying to get that.
Yeah, no problem. Take your time. And while you're doing that,
Representative Knight, before you ask another question, just allow the witness to please read the line and page reference in the bill so he can respond to your question. You will be recognized for a follow-up question.
If I can just get that, if we can go to another question, and I'll try and get that, ma'am, if it works, and we'll come back to that one.
thank you so much. My other question is, if that's the case, how will this relate to the active white supremacist groups in our state?
Commissioner, Representative Knight, that is out of order.
How is that out of order? We have white supremacist groups in the
Representative Knight, I'm really out of order. There's no foundation to such question. There's no restriction on firearm purchases based on race at all, anywhere in this country that I am aware of. That question is out of order, and the Commissioner, please, you do not have to respond to that question.
Thank you, sir.
Representative Burt, you are recognized for a question.
Thank you, Mr. Chairman, and thank you, Commissioner. Several questions ago, you said, and I hope I quote you correctly, NICS won't do the background checks as the New Hampshire State Police will do. The law, so here's the question, if you said this is what I heard. The law is very clear, so who is following the law? Is it NICS or is it the New Hampshire State Police on background checks? Because only one can do it if you're saying that NICS won't do the background checks as you guys do.
Well, yeah, just to clarify it, we do additional checks, but we also do the NICS check. So in our document that we're presented, what we will do that the FBI does not do is look further into a conviction, say a record in New Hampshire, to determine if it's a potential disqualifier. For example, if a simple assault had a domestic violence disqualifying factor in it, we do more, Representative Burt, is what I'm saying. But we also run the NICS check. So we do that as well. And when you say the law says we may be the point of contact, and that's why we worked internally to redefine the scope of these checks.
Representative Burt, you're recognized for a follow-up question.
Thank you, and thank you for the answer you just gave me. Also, you said, which I had the numbers approximately, in 2019 to March was 57,000 purchases of handguns, 87,000 to 2020 from January to March. This is what I'm being told, so there is a question at the end here. I went to a lot of gun stores and they're telling me that today they can get a background done approximately 5 to 10 minutes if you answer the phone. But where the problem is that the New Hampshire State Police is not answering the phone to 1 to 3 hours. Then they can get in, the gun store can get in to answer that, to do the next. So what happens if the sales jumps to over 100,000? How are you going to handle this?
So you actually asked two questions. So one is, why is it that at times you can have a permits and licensing employee answer the phone and give you customer service, instant approval? Let's just say there's no record. And why at times, and busy at times, does it take time? Well, the answer is, if we've got, 100 requests from FFLs in a matter of 10 minutes, obviously there's going to be a delay. It's just, it would be impossible to have 100, employees answering the phone. So what we've done is looking at getting the instant, customer service, and at least, having a system so that we can, and I think the FFLs understand that, sir, to be honest with you. I think they understand that it can't always be instant. I was asked the question, what does that mean, instant? Well, nothing's instant. You've got to, but the process that we are doing now is we're taking the calls as they come and trying to give as best service. So the average wait time is about 14 minutes is what I'm told. And again, it differs at, on our peak times. Did that answer it, sir?
Mr. Chairman, may I?
You may ask one follow-up question.
Well, I guess my follow-up is, I am not hearing this complaint on long guns because it goes to Nick's, and they have the staff to handle 100 or 1,000 calls in an hour. So, how are we going to fix this in New Hampshire so that way people are not waiting hours?
Sure. So, yeah, no, that's a good question. And I think, you have to really look at where we were in April of last year and where we are today. We were in a hole. There's no denying that, but we have made significant improvements here, like I've spoken to, and we continue to build on that. We've got a very scalable, flexible model down there. Just in the last 2 months, we've addressed some phone system delays. But again, I hope you would understand, a 63% increase in volume at a time where you're dealing with employees that could be impacted or out with COVID. And once you start getting those delays, it just continues to add. And the other issue, as I stated, is we are sometimes, a victim of other states not being responsive, when we have to reach out to get some data. So when we address that 88 days delayed, but we have really cleaned up the backlogs with the courts on the return of firearms. We've got the customer service, I would say, in a much, much better place. And if we go from, 87,000, we've already addressed that as we looked for these new positions in the budget. And I think with those positions and potential technology options out there, we get this. The majority of folks are approved. Okay, we have a very small number that go into delayed. They go into delayed for the right reasons. The clerks are looking and they're seeing something that causes it to be delayed. Getting it from delayed to approved to denied, we've really, I would say, upped our game there. And it was the policy, quite honestly, that allowed us to look and define the scope and balance the risk. Because again, calling 50 states individually to check and see if this individual has something in your state that could be a disqualifier that isn't in the FBI system, the III database, is just not it's not reasonable. It's not practical. So it's employees, it's technology, it's looking at our phone system. And again, the other thing is this, Representative Burt, it's engaging our customers more. It's talking to these FFLs and dealing with them. Some are small, some are busier at certain times, working better with them to ensure that we're giving them the service they need. But I would agree with you, the long gun check is different. But again, back to the question that's been asked several times, our check goes above and beyond that in several areas, which are, contained in the sheet that I've included. I hope that helps, sir.
Yes, thank you.
Representative Muse, you're recognized for a question.
Yes, thank you for taking my question. I did have time to review the sheet that you sent, and one of the things that I noted that you note is that there are several protections that are not included in SB 141 that look like they would be fairly significant and important protections. Without me taking the time to tell you what they are, could you just review how important you think those protections are?
Sure. And Representative Muse, I'm going to, I know that the courts have joined with us and they are going to also offer, but I'll just look at, the protective orders of somebody, and I've been asked a question, hey, why don't these, victims have a date of birth so that the courts can put it into NCIC? They actually don't put it into NCIC, which will be caught on a NICS check. And the answer is sometimes these are, and I'm not speaking to any particular case, but maybe just the victim just doesn't know the offender by date of birth, but wants to file the protective order, and those would be missed. So I think that's important. And the fact is, and I talked to the FBI, the head of the CJIS, and I asked, could this list that we get daily from the courts be entered into NCIC? And without a date of birth, the answer I received was no. So, and again, they've included the Child Protection Act protective orders, but I'm going to defer to the courts to speak in a little more detail on that. But I think they're important.
Thank you.
Representative Pantelakis, you're recognized for a question.
Thank you, Mr. Chairman. Commissioner, thank you for taking my question. It seemed as though with this bill, when they addressed it, they said, all you have to do is put it in the computer. And listening to you, I find that there's many other avenues that you have to go. Am I correct?
Well, I mean, we are doing the NICS check. The FBI does the straight NICS check on a long gun. So if you're comparing a long gun purchase today to a handgun, as I've stated, we are doing some additional steps. We're looking closer at our own database to ensure that something on this record is not a disqualifier. And we are also querying a list that we received from the Administrative Office of the Courts to ensure that somebody isn't under a protective order or bail conditions that would prohibit them from purchasing a firearm. So we are doing the NICS check. It's clear. I mean, and there's some folks that understand this and have been dealing in this world, but to keep it in the most simpler terms is we are doing additional checks, but not as expansive in the past, which was, I would say, caused, increased delays. So we've balanced it.
In some of those cases,
Thank you.
Representative Palmer, you're recognized for a question.
Thank you, Mr. Chair. Thank you, Commissioner, for taking my question. I'm just trying to clarify something you just said. You just said that if somebody gets a restraining order, they may not have the birth date. So would that imply that if Bob Smith had a restraining order out on him, but they didn't know what the birth date was, that everybody in the state named Bob Smith can't buy a firearm? Or how do you remedy that?
So the answer to that is we have a lieutenant that's in charge of the permits and licensing unit. And that's a very good question. How do they ensure that the person is not the person? And they can do further checks and inquiries to make sure they're not denying the wrong person. So it's with further checks. The other thing that hasn't come up either is sometimes it goes the other way, that what might look like a disqualifier is actually not, with further research and communication.
Representative Testament, you recognized for a question?
Thank you, Mr. Chairman. Thank you for taking my question. These other background checks that you do, I guess the domestic violence ones are in there. Do you keep a record, and would it be disqualifying if a person was consuming medical marijuana?
I'm sorry, I didn't hear that.
Do your background checks include whether or not somebody has been prescribed medical marijuana?
No.
Representative True, you recognized for a question.
Thank you, Mr. Chair, and thank you, Commissioner, for taking my question. What does it mean when you say run it through NICS? What is that? What is that process? What is the it? When you say and we run it through NICS, what is that process?
Sure. No, that's a great question. So if you look on page 2, I don't know who has it or who doesn't, but the NICS system searches. So this search will query against III, which is the Interstate Identification Index. Commonly, that you'll hear it in the police terms as III, which contains criminal history records if a fingerprint was obtained. Then you've got in the NICS index the NCIC, or the National Crime Information Center, which contains records regarding wanted persons, protection orders, deported felons, and other matters. And then we talk about the NICS index. The index contains records regarding all violation, misdemeanor, and felony convictions, regardless of fingerprint support, which are disqualifiers for federal and state firearms convictions. What I talk about when I say that our unit checks further into our own database, our own state criminal records, we know that not all of our convictions have been uploaded into NICS. So we want to make sure that there aren't convictions in our own state. We want to get New Hampshire, where it needs to be before we make the approval. So we're looking better at our own convictions, but we can't look at 49 other states. So we've got the NICS system searches. That's the best way to explain it. But there is a NICS index. So within that check that the FBI does, they query against those systems that I just explained. And again, it's hard to, but if you refer back to page 2 of our handout, you can see it in better detail, sir.
True, we recognize for a follow-up question.
Thank you, Mr. Chair, and again, thank you for taking my question. When I purchased the gun, it was a long time ago. So I don't know who got all my information, but I think I filled out a long application. So, do they take my application and fax it to somebody, and do they introduce my name and social security number, or are they looking at my mother's maiden name? Are they putting all sorts of information about me into the check, or is it basically just like my name and social security number and maybe where I was born?
It's a name and date of birth search, sir.
Thank you.
Seeing no further hands raised, I want to thank the witness for his testimony.
Thank you, Mr. Chair, members of the committee.
Chair recognizes Honorable David Wheeler. Just a reminder, the testimony will be limited to 3 minutes.
Unmute. Can you hear me now?
Right. We can hear you
now.
Yes.
You can hear me?
Yes, we can.
Okay. Thank you, Mr. Chairman and members of the committee.
I think what you just heard from the commissioner using a lot of words is the gun line is no longer broke. The problems that you're going to hear from other people and the stories that you're going to hear are old stories. The problems have been virtually fixed. There's always room for improvement, but they've been virtually fixed. Starting back in December, the Attorney General McDonald was engaged in writing a policy because it is true that the gun line needed more direction to know what checks to do and what checks not to do. So these out-of-state checks have been eliminated, and that has reduced the time that it takes to process the instant check process by far. The department has also added personnel, and the backlogs that we had in the return of firearms, getting firearms back to innocent people in domestic violence cases is virtually on time now. The backlog is gone. We had many cases that were backlogged well over 88 days. And NICS policy is if you can't clear it in 88 days, you clear the deck. That is now our policy at the state level. There are no delays beyond 88 days in New Hampshire now. Also in this policy, given and the directives to the gun line is that 90% of all inquiries will be answered immediately. And that is now the case. In fact, less than 3% of inquiries now are delayed, less than 3%. We've changed the way we've handled the inquiries. Every inquiry used to come in and be put in a box, and another person would have to pick up that inquiry, do the check, put it in another box, and a third person would call the dealer back. That is gone. That system is gone. When you get the phone answered by your gun line personnel, you get your answer 97% of the time. But that left us with one other problem, which was we can't keep up with the incoming phone calls because of the increase in volume. For example, many Saturdays, 400 handguns are sold. That's a lot of checks. So we had to make some mechanical changes to how we handle the calls. And now, just recently, in the last couple of weeks, we have a queued system, just like you hear at some companies that will say, you know, you either answer the call or your approximate wait time is 5 minutes or your approximate wait time is 10 minutes. And as you heard, the average wait time is no more than 15 minutes now. So the gun line is no longer broke, and there's still room for improvement. We now have a person in charge of taking faxes so that the faxes can be answered right away and not just piled up in a box and then someone calls them back when they get around to it. The department has done yeoman's work in fixing the problems at the gun line, and they really deserve some credit for getting that fixed. I don't see that sending this to the state sheriffs works. They talk about training people with $10,000 a piece. That's a one-time thing. You go from needing a few people on the gun line at the state police, you're going to need to train several people at each county and retrain people when they leave, when they're out on sick. You know, the gun line is a 7-day-a-week operation and many days, 12, 13 hours a day. I'm not sure the sheriffs are going to give that kind of service to the guns coming back from the courts. The guns coming, getting guns back to innocent people of domestic violence, they're caught up. They're doing their job, and we need to let them continue doing their job. So be happy to answer any questions. And I guess I would also say that the New Hampshire Firearms Coalition is in opposition to this bill as written. They would have one suggestion. If you want to take this written policy that the gun line now has and make it into administrative rules or make it into law that they must complete all checks instantly or 90% instantly, then that would be a good idea, and they would support codifying the policy that was put in place that is virtually and almost completely corrected the problems at the gun line.
Thank you for your testimony. Before questions are asked, Representative Wallace, would you be able to be in charge of the timer of each witness's testimony? Thank you, Representative Wallace. Representative Burt, you are recognized for a question.
Thank you, Mr. Chairman. Thank you, Executive Councilor Wheeler, for taking my question. Why do you think it is okay to use state employees and state tax dollars to fund a federal mandated program that the federal government will do for free?
So, well, thank you for the question, Representative Burt, and I appreciate you co-sponsoring the bill here, because if it wasn't for you highlighting the problem, maybe it wouldn't have got fixed. So that's the good news here. I think that we do a much better job at New Hampshire, and maybe most importantly, when there is a mistaken identity in the federal system, or when you have Robert Smiths, we do a better job at figuring that out right here in New Hampshire. And so far this year, I've brought 4 cases to the Department of Safety of people that were either long time delays or denies, and got them corrected and gotten their firearms back, because you, the 424 legislators and the counselors, can walk into that office across the river and say, look, we got a problem here. Sometimes it's an old conviction that's out there, 35 years old, and people forgot they had it. Sometimes we've had a case where it's the feds had wrong information in the computer and didn't read far enough when they put the documents in that said the case was dismissed. And we've corrected those situations, and all 424 of us can get those corrected if the state remains in the system, and that it works much better that way.
Follow up.
Representative Burt, you're recognized for a follow-up question.
Thank you, Mr. Chairman, and thank you for your, again, taking my question. Just last week, Saturday, I heard that a gun store pretty close to me, I was talking to the person, said that they spent about 2 hours trying to call into the gun line. Eventually, they answered their phone. So what my question is, have you experienced any of these delays? You know, because how many guns do you buy through a licensed dealer? So you may experience these delays.
Thank you for that question as well, Representative Burt. And I tell you what, several of us have been doing out in the field to verify what's going on inside at the gun line. Myself and other people that I know have taken on 3 or 4 gun shops and called them regularly and say, what do you see? You know, what's going on in the field? Tell me what the truth is. And these gun shops are telling me 2 things. One, the system has greatly improved, and they tell us where we need to fix things. And just recently, it's just been just recently that our queued up system has been added to the gun line. So I don't know how old this information is. And then we ask these gun shops a final question. If you had the choice, and if the New Hampshire gun line works well, would you rather have the Biden administration in charge of the gun line, or would you rather have New Hampshire people in charge of the gun line? And the answer—
Point of order. I mean, like, Biden? What is this?
Representative Knight, you raised a point of order, which you are permitted to raise, but all you said was yell about Biden. What is this?
Okay, my point of order is assuming that we're putting onus on a presidency.
Representative Knight, just to clarify, the point of order is appropriate when there is a challenge to the rules or the decorum being followed in the committee. So please expressly state which rule that is not being followed, and as the point of order you are raising, not that you your testimony.
Okay, thank you, Mr. Chair. So should I take a crack at it?
That's your decision.
Yes, I call point of order because I think that putting onus on the committee's responsibility to choose between a specific president and what we do as a committee and body for our state is inappropriate.
And that, I understand your point of order. I will allow the, and thank you, I will allow the witness to continue his testimony.
Thank you, Mr. Chairman. I will rephrase my answer, and I will say with bills like HR 1446 sitting in Congress and already have passed the House that could change the rules of how the gun line works, and no one knows for sure how that's going to come out of the hopper. I want New Hampshire in charge of denials and approvals. No one says the rules are going to be the same for the FBI and the state of New Hampshire when that legislation comes out of the hopper. If it says the FBI may delay 10 days all instant checks, then the state of New Hampshire would not have to delay 10 days, and we would be in charge and can still continue doing our instant checks instantly. So in the general gun control climate that's in Washington, I think New Hampshire should stay in charge.
Representative Hopper, you are recognized for a question.
Thank you, Mr. Chairman. Thank you, Councilor Wheeler, for taking my question. So is it your assertion that the state should bypass the federal NICS check if laws change in DC to alter the NICS check as it is now? Are you saying that we can just issue allow the sale of firearms and ignore the feds?
Thank you, Representative Hopper. To restate my answer, it depends on the exact language that Congress will come out of the hopper with HR 6. Should it even get out of the hopper? NICS is just a database, and how you do use that database could be given discretion to the states. If they say may delay, then we don't have to. It all depends, and I don't trust the way it would come out of the hopper down there, and I think we need to stay in charge. We need that flexibility. We need to be able to fix it when people are unjustly denied or false information gets entered into that database.
Representative Pantelakis, you are recognized for a question.
Thank you, Mr. Chairman. Councilor Wheeler, do you think that the state should give the department more people to help to implement this gun line?
Yes, I support the positions in the budget to give them the personnel they need to make the checks 100% of the time truly instant. And I think they've done a good job, using people who are need light duty work on workman's comp. It was a good place to put them. It's a good place to use some troopers who are actually troopers, but they hadn't gone through the academy yet. I think they're doing all they can to make it work now, but we do need those permanent positions.
Thank you.
Representative Alshaw, you are recognized for a question.
Thank you very much. Thank you, Executive Counselor, for being here today. And my question, I think I wanted to ask you, since the gun line has been, I have two questions. First, since the gun line has been in existence since 1993 and has served New Hampshire through 5 different presidential administrations, 2 Republican administrations, and now going into a 3rd Democratic administration, I heard your concern that somehow the gun line would be irreparably altered from its from the way that it's been moving since 1993. What is it? Could you elaborate on that concern?
First, I would state that I think the gun line has had problems in the past because they did not have a fixed policy at the state level. They have adopted the NICS rules of clearing the deck after 88 days. The NICS rules of 90% of all checks will be instant. And I'm saying that the climate in Washington has never been as anti-gun as it is right now. So things are different today. I'll also show you, I have next to me, hopefully you can see this, 500 pages of the NICS book, the guidelines that it takes to run NICS. 500 pages. I don't think that the money is sufficient for the counties to, because you talked about county money, Representative, I don't think that money is sufficient to train those people. And you're going to train 10 different counties to do the job that should be centralized on one person at the state level. It just isn't going to work at the county level.
Representative Alshaw, you're recognized for a follow-up question.
Thank you very much. I would agree, Executive Counselor Wheeler, that downshifting state responsibilities to the county is definitely something we want to avoid because it will raise our property taxes. My question is that on page 2 of the bill, and I don't remember if you had said you had it in front of you, do you? Or shall I read my?
Please read it.
Okay. Thank you for clarifying. So on page 2, for those who are following along, page 2, lines 8, 9, and 10, it is part 1, section C. Nothing in this chapter shall be construed to limit, prevent, or impose background check requirements on the private transfer of firearms as otherwise not prohibited by RSA 159 or federal law. So, regardless of anything else that's said in the 4 pages and fiscal note of this bill, there really is no infringement, would you say, on people being able to purchase a firearm? Maybe not the one they want at the moment, but the Second Amendment doesn't necessarily supply you with what it is you want, just what you think you need. So would you agree with that?
So you asked whether they agree with your statement. Please ask questions of the witnesses. The last time I'm going to make this warning to members of the committee. This is for everyone in the room, everyone remotely. You ask a question of the witness may answer. But members are not recognized to make a statement like that.
Sorry, Mr. Chair, could you clarify where my question was not appropriate?
Question.
May I answer that?
So why is your question not appropriate? The ruling is that it really wasn't a question. Then you corrected yourself by saying, do you agree with me? So they're asking me if he agrees with your question. So that's
No, I didn't correct myself. That was my question.
Representative, that's the ruling of the chair. The chair's made his ruling. I will allow the witness to respond to the most part of that statement. But the last warning I'm going to give, because we're going to have a very long day. If the members of this committee wish to make statements, you have my word, you will be recognized during an executive session to speak on the bill, or if you really want, you're free to testify. There's no rule saying you can't. The only difference is if you testify, you will not be permitted to ask questions. Last warning.
Thank you, Mr. Chairman. I would not interpret that language that way at all. I believe that language refers to the private sale of firearms, and it is saying that none of this whole background check stuff prohibits or can prohibit the private sale of firearms from person to person without a federal firearms licensed dealer, and they still would not need background checks.
Thank you. Seeing no further hands raised, I want to thank the Executive Council for his testimony.
Thank you, Mr. Chairman.
Chair recognizes Representative Horgan. Testify. Representative, just a reminder, your testimony will be limited to 3 minutes.
Hopefully I'll be done in less than that. I can, so learned a lot about a very complicated issue. I can only speak to the part about downshifting this to the sheriff's office. Just I've been on the county executive committee in Stratford County, which is medium-sized counties. Our county sheriff's department, like the state police, is already very, very busy. So even if it only takes supposedly 3 minutes to run a check on the computer, we have the dispatcher do it 11. That's still a significant burden. The one-time 10,000 payment, it's probably inadequate even for Coos County, which is about the size of Derry, of the town of Derry, but certainly it's grossly inadequate for Stratford County, and so it has to be paid for somewhere. Probably the fairest thing would be a fee, but that would be a new fee, which is very politically unpalatable, especially a new fee related to guns. So this is an unfunded mandate to the counties, and so even though this has to do with guns, which are maybe a higher priority for some of us and other things, that's still a unfunded mandate. And I don't see why, if the state police were struggling, why county sheriff's departments would necessarily not just face the whole issues if we dump that in our lap. So I think that's at least one sign for me that this whole bill appears to me to be, as we like to say, not ready for prime time. So I think probably my general impression is it's so deeply flawed that there's nothing you can do with it, and the limited time we have left to work on it. So I would probably recommend ITLing it, even though obviously the system we have is not working perfectly. So that's basically just my comment on it. There's a lot of I've learned a lot of technical details of a very, very complicated issue, and so I certainly wouldn't presume to address any of the other details. But just downshifting to the county, that's, especially with no training and no expenditure, that's just going to be a repeat of, they're just going to have the same struggles that the state police did. Oh yes, also I'm on the judiciary committee, so I can tell you the courts are not necessarily co-located with the sheriff's departments. The courts are judicial branches separate from county government, and actually a lot of these orders, probably most of them actually, are being issued by either the circuit courts or the family division of the circuit courts. So in many counties, including mine, we're not even, that court doesn't even meet at the courthouse. So that's so anyway, this they put a lot of work in this bill, but I think it needs so much more work to be to like pass. I think probably just gonna have to put it aside and ITL it or retain it or whatever. So thanks. I'd be happy to take any questions, although you've asked and heard a lot of questions already.
Thank you. Thank you, Representative, for your testimony.
Yeah.
Seeing no hands raised, the representative, you are excused.
Oh, thank you.
This time the chair recognizes Richard Head. It's a reminder, it's limited to 3 minutes.
Good morning, Chairman Abbas, members of the committee. My name is Richard Head. I am the Government Affairs Coordinator for the Judicial Branch. Just to point it out, the written testimony, the joint written testimony of safety and the Judicial Branch was sent out on my Outlook 247 yesterday afternoon. If you can locate it, or if you want to locate it, and was sent to the link for email to all committee members. My goal today is to provide information about the court's role, differences between the gun line check and the FBI check as it relates to the role the courts fill. Currently, we have staff that enters, modifies, and removes information that relates to domestic or orders of protection that are issued by the court. And this is really indirectly uploaded into the federal NCIC database. We use the SPOTS terminal system, the state police online telecommunications system. And from that, so we input directly into that system, which then automatically inputs into the NCIC system. NICS is not itself a storage of data. It's been, I would describe it more like Google, which then goes out and searches databases. And as you heard, searches 3 specific databases, NCIC, III, and the NICS index. And our data goes into where we can, through the SPOTS terminal into NCIC. There are really 4 areas in which orders of protection are issued: domestic violence petitions, stalking petitions under the Child Protection Act, and bail protective orders. So those are sort of the general areas in which protective orders are issued. And that, as a result of sort of that statutory setup and the way in which matters are filed with the court, that results in 3 places where data may be found regarding protective orders, and those protective orders may be disqualifiers. One is the data that we input directly through SPOTS into NCIC. The second is, and you heard the commissioner reference this, where a protective order is issued, but the party filing it does not know the date of birth of the defendant. And those are not your criminal cases, those are civil protective orders, where the party who is filing simply doesn't have a relationship with the defendant that suggests that they know the date of birth. So we have, and it's a changeable list, of about 50 to 70 names at any particular time where a protective order is issued, but the court has no information available to it about the date of birth. And therefore, we cannot upload it into NCIC because that date of birth is an essential component of what we put into the system through SPOTS. So we have a separate list. We fax that to state police on a daily basis so that is one of the databases they check in addition to NICS. And then when the sheriff makes service or whatever the other system is where we get a date of birth, we modify our list, we input it into NCIC through the SPOTS system, and it comes off the no known date of birth list. So at any particular time, there are 50 to 70 some odd names on that list, but it changes regularly as we learn date of birth, they come off the list, new filings come on, and they go on the list. And then the third category are the emergency domestic violence or the after hours criminal bail protective orders, CBPO. And they just, because there's a manual process for inputting data into SPOTS and therefore NCIC, that data has to get, there's a delay, although state police can have access to it. It's not a long delay, but there is a delay. So as a third check, Gunline looks into that. If you don't have it in front of you, I'll describe it, but on page 4 of the written testimony we provided of the joint testimony, it outlines 3 graphs about how these systems work and what is reviewed and what would not be reviewed if it changes to a FBI NICS check only. And currently, as I said, the big issue is going to be the list with no date of birth, where there's a protective order issued. The other is the emergency domestic violence or the after hours criminal bail protective orders. And then you also heard the commissioner refer to the Department of Safety's database, where they have essentially all the criminal cases. And what happens is they check their database. If it comes across a name and that does not have on their database, and this is where I'll correct Senator Guida a little bit, it's not the judicial system's database, it's the Department of Safety's database of criminal matters. If they, in their database, do not have a disposition of that case, they contact the court clerk, find out what the disposition is. If it was something that at that point should be uploaded into one of the NICS databases, they do so. And if it shouldn't, then it's not a disqualifier. So the interaction with the court is safety will reach out to the court system, find out the disposition, and then update their records. And really what we're talking about is the clerk gets contacted for records that are essentially, I think all the time, pre-Brady bill matters that are in the Department of Safety's database. So essentially pre-1993. The other thing that's missing and is described in our testimony is under RSA 173B, the domestic violence statute, if a person who is subject to a protective order attempts to purchase a handgun, the courts are notified, and the courts notify the person who is protected by an active domestic violence order to inform them that there was an attempt to purchase a weapon by the person who the domestic violence order is issued against. And that allows that person to take whatever additional safety measures that they believe is necessary for their own protection. If the FBI were to conduct that search, they would not be reaching out to the courts to say that there had been a contact. So that's an element that would not be followed should the bill proceed. The other aspect of it is within the bill itself. On page 3, line 22, it describes orders that are issued by the court under 173B, which is the Domestic Violence Act, and 633:3-A, which is stalking, and putting those directly into the NICS system. What's very unclear to us is what that means, is because we don't directly input into NICS. We indirectly input into NCIC through the SPOT system. Unclear if that would still be allowed, but it does not include, and therefore we would not have under this as written statutory authority to enter into the system protective orders under 169C, which is the Child Protection Act, or RSA 597, which is where those bail protective orders come into effect. And they're simply not described in the bill.
Mr. Head, I do have to, we did limit testimony 3 minutes. We did allow.
I apologize. I appreciate the additional time. I'd be happy to answer any questions that the committee may have.
I'm going to get yelled at for how long I let you go on for, but.
Yes, you are. 11 minutes.
But I do appreciate your testimony, but I do have to ask to conclude. But the chair prior would ask a question, and I want to thank you for taking my question. Can you describe the process of when, if someone does have a disqualifying condition that would prevent them from purchasing a firearm, it's in the NICS, what is the process of removing that disqualification if it were, like, for example, if a domestic violence restraining order would expire?
Yep. So similar to the process of putting in, and again, we go into the SPOT system. We have the ability with SPOTs to enter, to modify, or remove. So as the status changes of a protective order, that data can be done by our staff relative to the protective order itself. And then with regard to the date of birth list, as we get a date of birth, that is then updated and uploaded into NCIC through SPOTs, and then would come off the separate no date of birth list that we maintain.
Thank you for taking my question. Representative Hoffer, you're recognized for a question.
Thank you, Mr. Chairman, and thank you for taking my question. A little bit of a hypothetical. Let's say this year the federal government changes the criteria for a NICS check and decides that any NICS check will only be issued 5 days after it's been requested. Does the state have the authority to bypass that NICS check and issue release to allow a gun sale anyway?
So I think thank you for the question. If I understand correctly, if you're saying that the federal government change would prohibit, essentially, would have a required 5-day delay, I think the answer would be if the gun line, and I'm making an assumption here under what that law would say, but if the gun line were able to access NICS and were able to obtain information from NICS in less than 5 days, even though the FBI might be limited and prohibited from issuing in less than 5 days, it would really depend upon how the law was written in Congress. If Congress did not prohibit a state authorized program from issuing in less than 5 days, then they could issue in less than, and the person was qualified, they should be able to issue in less than 5 days. If Congress preempts the federal or the state program from doing that, then I would assume it would be required to follow the same 5-day rule. But it would depend on how Congress wrote that law.
Thank you.
Representative Burr, you recognized for a question.
Thank you, Mr. Chairman, and thank you for taking my question. You said, you know, in your over 11-minute speech about domestic violence, that the state police have access to that. Now, in the bill, we have the sheriffs that's going to do that part if this bill passes. Do you believe the sheriff will do just as good of a job as the state police is currently doing on making sure that NICS understands that this person is prohibited?
So thank you for the question. I did not realize I'm on 11 minutes. When you're talking, it seems quicker. The one thing to make sure is clear is that the sheriff's role in the bill is limited to where there's a petition for return of firearm. And that's where Senator Guida mentioned there are about 450, 500, and sometimes there are as many as 600. But they would be essentially the court's interface with the FBI system, with the federal system. And for those only, the sheriffs would be responsible for getting the NICS response back to the court so that we could determine whether or not the petition for return of firearms should be granted or not. If it's a request from a federal firearm licensee, firearm licensee, that does not, as I understand the bill, go through the sheriffs. That is a direct FBI request. So just to clarify the way the two lines in which requests are made. Separately, though, with specifically to your question, as written, no, the no date of birth list and the Department of Safety's list of matters would not be searched by the sheriff or the FBI if it's the federal firearm licensee that's doing the search, nor would they have under the bill the emergency domestic violence or the after hours criminal bail protective order list.
Representative Burr, you are recognized for a follow-up question.
Thank you, Mr. Chairman, and thank you for taking my follow-up. But if I understand correctly, the bill instructs the courts to clean up their records, which, you know, I understand needs cleaning, and they are going to report this, you know, to NICS.
So thank you for the question. I don't think the bill requires us to clean up our records. One, just on that point, the records we're talking about. So there's, and I had mentioned this, and I think Senator Guida had mentioned this. There are about 170,000 records that are in the Department of Safety's database. It's not a court database, in which the Department of Safety, when they run the search on their database, if it hits one of those 170,000, that's where they call the court and say, hey, what was the disposition of this matter, so that we can update our, meaning the Department of Safety's database. There is nothing in the bill that instructs a cleanup of that. And as I had put in my fiscal note to the Senate, which may be the one that you just received, because I had asked the clerk to why it wasn't attached to the bill. If we had to receive that list of 170,000 today and clean and essentially find out the disposition of what is in Department of Safety's records, there would be a significant fiscal note associated with that search, because we would have to do it essentially all at once instead of the current system, which is if there's a hit, the Department of Safety reaches out to us. We spend the time to find out what the disposition is and report that back to the Department of Safety. And I think you had a second question, which I apologize. I'm not sure I remember.
I did not. No.
Okay. Thank you.
Representative Altshuler, you are recognized for a question.
Thank you, Mr. Chair, and nice to see you, Mr. Head, in a different committee. My question today refers back to your testimony. You testified that is that correct, that there are 50 to 70 names at any particular time that don't have a date of birth attached? And do you know if of those at 50 to 70 names at any one particular time, how many of those are domestic violence, stalking, or child protective issues?
Thank you for the question. They are all within those statutes I had mentioned: domestic violence, stalking, or child protection. So that's where the protective orders are issued through. And as I said, that's a 50 to 70 is about the average that will be on that list at any one time. And it's a continuously changing list as we learn dates of birth or new matters are filed where we don't have dates of birth. And again, in our written testimony, we provided some examples of how that could come to happen. For example, a store clerk who is asked out on a date, who declines, who then the customer becomes more aggressive and starts threatening. And ultimately that clerk gets a protective order because of the nature of the threats that are being issued against that clerk. The clerk has no reason to know the date of birth, but it would fall within the stalking petition. But they don't have that type of relationship to know what the date of birth would be. So when that ultimately that complaint gets served, the sheriff can identify that or can learn the date of birth from the party, or in a filing that it happens at the beginning, the court can get the date of birth, and then that list would be updated. Mm-hmm. And we try to do it obviously as quickly as we can, but it is dependent upon when that data can come back from the sheriff, or if not from the sheriff, when the party files.
Mm-hmm. May I follow up, please?
Representative Alshua, you're recognized for a follow-up question.
Thank you very much. So, Mr. Head, referring back to the example that you just gave, since the clerk in this example doesn't have the date of birth, but files for an emergency protective order through 633-3 for stalking, would the person that is the order, who had been harassing her or him, would that person now, because there's no date of birth attached to that, be in a space where they would be able to purchase a firearm through a gun dealer?
Thank you. Thank you for the question. If the check were to go only through NICS, so the part of the gun line that goes through NICS or FBI, which only goes through NICS, they would not see that person because the data cannot be entered into the database without the date of birth. So they would just be invisible to the FBI. But because Gunline does receive that list, and Gunline does review that list when a request comes in for purchase, they would then be able to say there's a disqualifying event as a result of the protective order. And as you heard from Lieutenant McQuaid, it does require some additional research on their part because, they're not all John Smiths. They may have unique names, but they need to then identify whether or not there is sufficient information to say whether or not there's a disqualifying event. But they do have that list, and Gunline does review it every time they have a request. And if there's a hit and it's a disqualifier, then that would be disqualified, which would just not be seen by the FBI.
Thank you.
Representative True, you're recognized.
Thank you, Mr. Chair. Thank you, Mr. Head, for taking my question. Obviously, I don't know much about the gun line. I should be asking for a friend, but somebody said, I think, that the gun line is only authorized to use the NICS system, which is a name and date of birth data entry. So my question is, if somebody's going to buy a rifle, that the gun dealer gives information to the FBI, and the FBI runs a NICS search. as opposed to in New Hampshire, if somebody wants to buy a firearm, the gun dealer gives that information to the gun line and they run a NICS search. Is there any difference between the NICS search the FBI did with a rifle and the NICS search the state of New Hampshire gun line does for a pistol?
Thank you for the question. It's a great question because I think it is worth clarifying this point, which is really what does the statute say as to safety's role, and it's 159-D:1, which says the Department of Safety may become the point of contact for the federal government for the purposes of the National Instant Criminal Background Check System, NICS. And that's the statutory, that's the requirement in order to become a point of contact for FBI. It does not say, and really the question should go to the Attorney General's office, but my understanding is the Attorney General's office and the Attorney General worked with the Department of Safety to come up with a policy based upon the statutory authority. But it does not say, Department of Safety, you can only do a NICS background check. It is an authorizing statute, which is required. Department of Safety, you are authorized to become the point of contact for the federal government for purposes of NICS. And then we have in fact implemented that and through what we call the gun line, but the permitting group at the Department of Safety, they are the point of contact as authorized by the statute. It does not, in the content of that statute, limit them to NICS. It just simply says that they can be, it may be the point of contact. But I think in terms of the authority of safety, it's a better question for New Hampshire Department of Justice and the Attorney General, but it's at least my understanding that the Attorney General has been working with the Department of Safety and putting that policy together within the context of the statutory authority.
Thank you. Representative Newman, you're recognized for a question.
Thank you, Mr. Chair, and thank you to the witness for taking my question. In the bill I don't have all the line numbers, but on page 2, section 2, it says that RSA D 159D1 and 159D2 are repealed and reenacted to read as follows. And it's very difficult when they completely repeal something to compare the new to the old. Could you just briefly describe what differences you see in the changes that were made to those two laws?
I'm sure. They are, I think, fair to say nothing alike. So 159D currently gives the gun line, through essentially the Department of Safety, authority to be the point of contact. And then the current version, excuse me, of 159D2 instructs the Department of Safety regarding confidentiality. And section 3 of 159, and it's only 3 sections, talks about the penalties for the attempts to purchase illegally. So I think it's fair to say, and I agree with your point, it becomes incredibly hard to compare when it's just a complete replacement, because the bold or the strikeouts. But in this case, I think it's fair to say that this is entirely new, and then by virtue of what's at the end of the bill, under section 5 of the bill, it says the New Hampshire State Gun Line in the Permits and Licensing Unit of the Division of State Police, Department of Safety is hereby abolished. So it essentially eliminates the gun line in part 5 of the bill, and this section is entirely new. And I do point out, this in that section that you're reading, page 2, it references restraining orders under 173B and 633:3A, which are domestic violence and stalking. But again, in that section, similar to what's in part 3 of the bill, where we're authorized to input data into NICS, It does not include 169C, the Child Protection Act, or 597, the Bail Protective Act, I'm sorry, the Criminal Bail Protective Orders. They're simply not referenced in either of those two sections of the statute, but both are important sources of information regarding protective orders for those who have protective orders for their safety.
Follow up.
Representative Newman, you're recognized for a follow-up question.
Thank you. And thank you for that description. But based on that, do you think that the changes that have been made to those laws would be more effective in correcting the problems that you wrestle with as far as being able to identify people and being able to identify whether the current restraining orders and all that kind of things that you mentioned, does it make it better or worse to be able to carry out the changes that you think you have done?
Thank you. I think it, as written, the bill would, and really actually probably can't be written any differently if the FBI is doing the search, because the bill, the purpose of this bill is to provide a NICS system only background check. And that's the end of the search if this bill were to pass. And what that would not then ever see, because the FBI simply can't see it because it doesn't and can't be uploaded to NICS, is the list of 50 to 70 orders or parties and the defendants in those cases where we don't have a date of birth, and that just can't change. Or two, if those that are the emergency domestic violence or the after hours criminal bail protective orders, which do not get immediately uploaded into the system. And there, even if there was a way to put and my understanding is there's not, but even if there was a way to put a person's name into the NICS index without a date of birth, and everything I've seen from FBI guidance says that you need a date of birth. But if you were to be able to, FBI still wouldn't capture that because they're looking for person and date of birth. And that date of birth simply doesn't exist. So the search that is currently done by Gunline would just simply not be replicated through this process. And that's I get that's a policy decision of the legislature. And so what my purpose of my testimony is simply to identify those areas that would change substantively, which are, there are these important areas where there is a domestic violence order that would simply not be captured in a short window of time by the FBI. And within that window, a handgun purchase could be made that under the Gunline system would get caught and a disqualifier would be identified. And on the flip side, as Commissioner said, in the NICS database, so for example, if sometimes the data doesn't always get uploaded. So if we have a New Hampshire resident who lived in Georgia and that shows an arrest in the NICS database for a disqualifying event, but the arrest is relatively old. The Gunline can reach out to Georgia and find out if there was ever a conviction or if it was found not guilty. And that data simply did not get uploaded into NICS because NICS is only as good as the data that's uploaded to it. And if in fact that case was dismissed or there was a not guilty finding, then what could come out as a delay or a disqualifier from the FBI would get processed by the Gunline as qualified because the additional research that the Gunline does, that FBI simply doesn't.
Thank you.
Thank you very much for that clarification, and I think it helped a lot in clarifying the differences between the two systems. Thank you.
Great. You're welcome.
No further hands raised. Representative Green.
Yes, Mr. Chair, thank you. Mr. Head, could you tell me, I'm Representative District 13, Rockingham County. Could you tell me how many sheriff's departments are open on weekends?
I cannot know.
I know when I drive by my sheriff's department.
Representative Green.
Sorry.
I will, Mr. Chairman, I'm sorry, if I could just add one thing.
Question, so it was a statement, and I don't believe any response is necessary.
Sorry.
We're trying to avoid members making statements when they're recognized for questions.
Apologize.
Seeing no further hands raised for questions, I want to thank the witness for his testimony.
Thank you, Mr. Chairman.
At this time, the chair recognizes Sean List. And as a reminder, testimony will be limited to 3 minutes. I will do a better job of trying to enforce that.
Thank you, members of the committee, for allowing me to speak today. Are you able to hear me? I can't see the mute on my.
Yes.
Perfect. So my name is Sean List. I'm a lawyer practicing here in New Hampshire. I focus on the area of firearms law. Sitting next to me is Jim McLeod, the owner of Shooters Outpost. We're actually at Shooters Outpost as I testify now. I'm not going to go into my credentials and waste time. I will say that I spend a significant amount of time, in addition to gun law, representing domestic violence victims through the Domestic Violence Emergency Project. It is a primary interest of mine. So I want to correct some things as quickly as possible. First off, I just want to point out that I think it's beyond clear now that the Department of Safety and the judiciary are, in fact, in opposition to Senate Bill 141, despite stating that they're taking a neutral position. They won't make a single positive statement about the bill. All of this being said, well, allow me to explain that the NICS system, first off, is not just a series of databases. There's a call center in West Virginia that is staffed with a massive staff that actually does do research. I'm not sure where this false presumption that they don't do research comes from. Just to give you an example, it's very common for people to be denied based on having a domestic violence qualifier by the feds, even though it's just charged as a simple assault. Prior to Joshua's law passing in New Hampshire and modifying 173B, people were denied for that disqualifier all the time. So this idea that they do not do research is completely false. The reason that there is a delay, the reason that there's a possible response of delay instead of approve or deny is so that they can do that very research. The real issue that no one has addressed thus far regarding the protection of victims is the fact that right now, the state police, yes, for handguns, they're maintaining some sort of sloppy paper copy or Excel spreadsheet copy record of restraining orders, but they're not sharing that information into the NICS index. The vast majority of states, and I included the map in my written testimony, the vast majority of states do not use a point of contact system. What they do is they're allowed by federal law to upload state prohibitors into the NICS indices. So the NICS indices is basically the catch-all for any prohibitor information that a state wants to enter, separate and apart from NCIC or the III database. All you need to enter a state prohibitor into that database is the name and the date of birth, or the name and the social security number. Now that list of 50 to 70 individuals without a date of birth, that is entirely useless. And this idea that, oh, the date of birth may not be known because it could be a stalking issue, well, those restraining orders don't go into effect until they're served on the person. And if the police are serving the person, they know that person's date of birth. So it's another just example of sloppy record keeping. Our state statute, RSA 159D1, it simply allows simply allows the gun line to be the point of contact for NICS. That's the intermediary. NICS still runs the background checks. There's absolutely zero state authority, and the gun line does not operate under any agency rules, allowing them to do off-the-cuff determinations regarding whether someone is a prohibited person or not. In the current system, given the fact that they're not sharing restraining order information into NICS,
Let's suspend them.
they may block someone from buying a hand.
Excuse me, Mr. Attorney List, I do have to ask you to suspend for one moment. You mentioned that you were present with a Jim McLeod, who's also signed to testify. Because the timing did expire, but if you are together, if Mr. McLeod is gonna yield his time to you, I will allow you your testimony to continue. If that's the same person.
So Mr. McLeod will yield his time so that I can continue testifying, particularly in light of Attorney Head testifying for more than 10 minutes, and I'm trying to respond to it. So I'm not sure where it cut out, but the point I was making is our state statute specifically permits the state tax as a point of contact. It does not permit it to do all these additional checks. They don't have any authority to do that, but the state could be just putting that information into NICS. So people who have active restraining orders against them, they also would be prohibited from buying shotguns. Put a different way, currently, they may block someone who's got an active restraining order against them from buying a handgun. That same person could go buy a shotgun or an AR-15 because of the fact that the Department of Safety does not upload that information into NICS. Now, the gun line uses the excuse that the delays are because of an influx and an increase in calls. There was a 71% increase on the federal level that NICS experienced. It went from, sorry, I'm getting an echo there. It went from just over 28 million checks in 2019 to 39,695,000 in 2020. And guess what? NICS kept up with it. The issue that we're seeing with the gun line is the fact that, frankly, we are allowing people's Second Amendment rights to be held at bay at the leisure of bureaucratic whim. For example, I represent individuals who appeal denials of firearm transfers on both the state and the federal level. The gun line is supposed to follow federal law, which requires specifically that within 5 days of a written appeal, they provide a reason that someone's been denied. They simply don't do that. So the fact that they don't even follow federal law makes it very hard to accept the idea that they're going to follow some agency principles or agency policy in place. What's further concerning is the fact that these federal background checks, they're supposed to be done in accordance with very specific regulations, 28 CFR 25.5 and 6, and very specific statutes. What we're basically being told is that the gun line is taking it upon itself to do all these extra checks that neither the legislature or the Department of Safety through rulemaking has set the framework for, and they're allowed to affect people's constitutional rights kind of behind the curtain. In the last year, I saw people who had guns taken away from them in court that even if there was a restraining order that was temporary, 3 days it expired, they couldn't get it back for 10, 11 months. There was a crisis going on at the court level. They were totally log jammed. And by the way, right now, there is no way for a person who's wrongfully denied the return of firearms to appeal it. Senate Bill 141 fixes that. It requires a very specific time frame for the checks to be run, and also it gives appeal rights for individuals who are wrongfully denied. Also, let me make the point about downshifting to the sheriff's office. The vast majority of background checks that occur in the state by the gun line are handgun purchases. The return of firearms in court, that's a secondary function. That's actually something that was created by Protocol 11 by the court system, not even by statute. And that's only about 400 to 450 checks a year over all 10 counties, according to the chief circuit court judge. These background checks for purposes of the return of firearms are simple. So simple that The NICS system is currently being used by police departments all over the state to issue licenses to carry, and they don't even get additional funding to do that. So this idea that it's going to be some, some arduous undertaking or it's going to require significant funding is false. I just want to make the point that as it currently stands, what we're doing is we are spending hundreds of thousands of dollars a year on a system that just adds an extra layer of government bureaucracy when the federal system works all over the country. States that have piles of state prohibitors, like New York and Massachusetts, they use only the feds. What we have here is a situation where the Department of Safety does not want to update its own records so that the appropriate information is going into NICS, which would not only allow people to enjoy their Second Amendment rights, but it would protect victims of domestic violence. So I'm happy to take any questions that you may have. Frankly, go ahead.
Thank you for your testimony. The chair recognizes Representative Pantelakis to ask a question.
Thank you, Mr. Chairman. And thank you, Sean, for taking my question. I would like you to give me some reasons why you believe that this is better at the county level than at the state level.
Sure. So basically, as far as the return of firearms in court, that limited function that would be served by the sheriff's office, the reason that I think this would be better is, number one, sheriff's offices, they are the only constitutionally created police agency in the state. They have regular interaction with the court system. And frankly, they do a lot of functions outside of what officers learn in the police academy. So like right now, they serve civil process, right? And they carry on functions in unison with the court system regularly. So having them in the court, directly accountable to the court system, to judges, a judge could frankly ask, the sheriff's office, so when can we expect a response on that firearm related background check? And they're right there. So I think it's just makes sense to change it from the Department of Safety given the issues, but the sheriff's office seemed like a good choice.
Thank you.
Representative Burt, you're recognized for a question.
Thank you, Mr. Chairman, and thank you for taking my question. I was hoping to hear from the owner of Shooters, and I do apologize that you had to use his time, to finish your talk. But I was wondering, what is the impact on gun buyers and owners with these delays that have happened in the past and that may happen in the future?
So that's a great question. It's been a significant issue. So I represent gun dealers all over the state, and Shooters Outpost and Jim McLeod, they're the biggest gun dealer in the state. And what I can tell you is that the delays caused by the gun line, they have led to situations where firearms are just sitting, not on the shelves available for purchase, sitting, waiting for the state to come back to them. And the issue is that there's only so much inventory that smaller shops can carry at any given time. And having it tied up, they haven't received payment for it. There was a real economic disadvantage that they suffered. And the delays, someone asked earlier, why is it that the delays are occurring? Being someone that's in litigation deposed the gun line folks, and notably, we don't actually ever hear from the gun line people that run the checks. I can tell you there's a fundamental misunderstanding of the prohibited categories and frankly, understaffing over there. And just one other point to answer your question, the delays are also frequently caused by this 50 to 70 person list where there's no date of birth, because that's not enough to block someone who's prohibited, but it certainly is enough to delay someone who shares the name with someone who's prohibited.
A follow-up.
Representative Burt, you're recognized for a follow-up question.
Thank you, Mr. Chairman, and thank you for taking my follow-up. Representative Hopper asked Mr. Head a pretty pinpointed question, and he kind of, he did pretty good dancing around the answer. So I just want to ask you the same question. If I get it right, I hope.
Representative Burt.
Yes.
Just ask the question, please.
All right. Thank you, Mr. Chairman. Hypothetically, if the federal government mandates a 5, 10, 100-day wait, New Hampshire State Police, when they do their NICS background checks on handguns, will have to follow that rule, that law.
That is absolutely correct. And I would suggest that, if other attorneys who don't practice in gun law want to understand this interplay better, that they take my continuing legal education course that I teach to lawyers. I'm doing it in June. What I can say about federal gun law is that it is preemptive and holds supremacy over state law. That's by Article 5 of the United States Constitution, the Supremacy Clause. The NICS system and federal background checks, they are governed by the National Firearms Act of 1934, the Gun Control Act of 1968, the Firearm Owners Protection Act of 86, the Brady Act of 93, and the Lautenberg Amendment in 97 that added domestic violence indicators. Federal law absolutely governs all background checks. There is no situation, we don't have state firearm background checks in New Hampshire. We are carrying out the work of the federal government, and they're a part of every step of it. There's no situation where we do an end run around any federal regulations, around any federal laws pertaining to firearms, period.
Chair recognizes Representative Klein Knight for a question.
Thank you, Mr. Chair. Thank you for taking my question. Moments ago, if I heard you correctly, did you say you participate in selling firearms in our state? Is that correct?
I do not.
Okay, thank you. No further questions.
Do you wish to be recognized for a follow-up question, Representative Klein Knight?
No, I think she said no.
Representative Alshiller, you are recognized for a question.
Mr. Chair, and thank you for taking my question, Mr. List. I am unfamiliar with you, so I would have appreciated hearing your qualifications and background on this, but I've discerned that you represent gun dealers. Could you tell me, are you a registered lobbyist?
I am not a registered lobbyist. I'm doing this 100% on a volunteer basis. I represent gun dealers in a legal capacity, not on a lobbying capacity. I'm not being paid to testify. My credentials are, so again, I represent firearms dealers around the state. I also practice plaintiff's employment law. I also represent victims of domestic violence and sexual harassment. I'm a certified firearms instructor, a competitive pistol and rifle shooter. I belong to the National Shooting Sports Foundation, and which is a trade group for firearm affiliates. Basically, I practice primarily in the areas of guns and stopping people from being discriminated against, frankly, which makes me one of the most controversial people in New Hampshire, I think.
Representative Klein Knight, your hand is raised again. Do you wish to ask another question?
Yes, please, Mr. Chair, and thank you. So my understanding now that I just heard you speak is that you represent people that do sell firearms. Your clients directly will gain more money if this bill were to pass, correct?
So I'm not sure if they'll gain more money or not. That's definitely a possibility. I represent both dealers and I represent individuals. So I do appeals involving denials of firearm transfers for individuals on both the state and federal level as well. Ultimately, you know, the gun line, it going away because it causes so many problems, and I have to threaten to sue them to get them to answer so frequently. Supporting this bill, and actually I'm the drafter of this bill with Senator Gaida. You know, this bill will actually hurt my bottom line because, you know, then there won't be as many cases dealing with the gun line.
That's funny. Thank you.
Representative Wallace, do you wish to be recognized for a question?
Yes, thank you, Mr. Chairman. Thank you, Attorney Listen, taking this question. Part 6 of the bill references immunity for the sheriffs. Why should the sheriffs be granted immunity? And part second of that question is, does the New Hampshire gun line currently have immunity for the people that work there?
Representative Wallace, you kind of faded out there at the end, but I think I caught the whole question. So the inclusion of that immunity provision regarding the sheriff's offices carrying out their duties under the chapter was added after you know, they had raised concerns about possible legal liability, et cetera. You know, the immunity as far as the sheriff's offices go, it really won't have an impact on individual rights because of the fact that there is such a well-defined appeal process. So the checks for the return of firearms have to happen within, they have to be initiated within 10 days, finished within 15 days, and an individual gets an immediate appeal at no cost if they're aggrieved by a decision by the sheriff's office. So it's really a balancing of the two.
Seeing no further hands raised, I want to thank the witness for his testimony.
Thank you very much.
At this time, the chair recognizes Gary Fisher. Just a reminder, your testimony will be limited to 2 minutes. 3 minutes.
Chairman Abbas, can you hear me, sir?
Yes, we can hear you, Sheriff.
Good afternoon, Chairman Abbas and members of the committee. My name is Gary Fisher, and I am the Chief Deputy of the Hillsborough County Sheriff's Office. I have been in law enforcement for over 35 years. I am also a federal firearms licensed dealer. I appear before you on behalf of the New Hampshire Sheriff's Association with a neutral position on this bill. We met with Senator Gaida and worked with him to craft some amendments to the bill when it was introduced into the Senate. However, there is an outstanding concern. We respectfully ask that you make the following change to RSA 159D:1, 2B on page 2 of the bill. You'll see in that section that it refers to when the motion is filed with the court and the time clock begins to run. I'll quote from the bill. The county sheriff's office shall initiate the NICS background check within 10 business days of the date of filing of the motion or other pleading requesting the return of firearms. Sheriff's Association is asking that the wording, the date of filing, be replaced with receiving in that particular section. Also under 159D:1, 2B, within 15 days of the date of filing of the motion, we'd request again that the date of filing of the motion be replaced with receiving the motion. The only other concern that the Sheriff's Association, and it's been addressed quite a bit already, is the cost that's associated with it. The Sheriff's Association is not sure what the cost would be involving these checks. I'm aware of one county, which would be Coos County, that does not have the hardware to accomplish this. They depend on other local law enforcement agencies to run their checks for them. So, and I know that this has been discussed, and it's, Senator Gaida brought it up in his opening regarding being able to use a 6-month period to address this. All 10 sheriff's offices will be required to train personnel regarding submitting, receiving, and receiving NICS information, as well as the state and federal guidelines as they relate to the possession of firearms by prohibited persons. Additionally, all 10 sheriffs are not in positions to absorb the commitment that will be required with the personnel they currently have on staff. These are the issues that the Sheriff's Association are bringing forward. Again, we've attempted to address this with Senator Guider in the onset, and they still remain unresolved. I'd like to thank you for your time and entertain any questions if the committee has any.
Chair recognizes Representative Pantelakis to ask a question.
Thank you, Mr. Chairman. I would like to ask a question if the sheriff has an estimated number of people that they would need.
Representative, thank you for the question. We're unaware. We're told that there's between 400 to 500 of these checks that occur on an annual basis. Being from Hillsborough County, being the largest county, I have to make an assumption that this county would probably receive the most inquiries for the return of firearms. The information that's been provided you from other testifying individuals is that it takes a short period of time to run it. That is correct. We run it in through the database, which we do on a regular basis for other things. It would probably be done by our communications personnel. With that being said, it would be an additional burden that would be placed on top of what they're already doing. So to say that we would need to hire an additional dispatcher or an additional clerk, that is unknown at this point. We're not in a position to be able to say whether or not that would occur.
Thank you.
Seeing no further hands raised, I want to thank the sheriff for his testimony.
Thank you, sir. Thank you, committee.
At this time, the chair recognizes Penny Dean. And just a reminder, testimony will be limited to 3 minutes.
Yes, thank you. My name is Penny Dean. I live in Concord, New Hampshire. I'm an attorney. I've been licensed over 20 years. I'm licensed in Maine, New Hampshire, Massachusetts, DC Circuit, admitted to the federal courts and the First Circuit Court of Appeals in those areas, as well as the United States Supreme Court. And I won't take all of the committee's time with my firearms certifications, but I am a hunter education instructor, a pistol instructor, and I have several other credentials. But what's most important to me here as a gun owner is this bill is poorly drafted in exhibits in every shape and form, and I certainly can't outline them all, a fundamental misunderstanding of how the courts work and how firearms work, as far as how firearm checks works. And first of all, my torts professor would say, back up the money truck. And here's what I can tell you. As an attorney, if this bill passes, I'm going to make multiples of the money I make now. And here is why. If a person is denied a handgun, they get a denial number. I send a release to the gun line, usually within hours, but certainly within 24 hours, and at most maybe a couple days, usually within a day, a few hours. The New Hampshire State Police gun line tells me why the person was denied. They tell me the court the denial was in. They tell me the date of the denial. They tell me the docket number of the denial, and they tell me the specific statute the person's alleged to have violated. That means all I have to do is go to the court and see if that is a disqualifier, see if it is my client, and it becomes a very simple exercise in either saying, yes, this is my client, we have to get it annulled, no, it isn't my client, or no, it's not disqualifying. It's very simple. When I give the New Hampshire State Police gun line that information, usually within hours, but I don't recall it ever being more than a day, although it might have been, they have an answer back for me. I bring them certified records, and the answer is, of course, your client is now allowed to purchase a firearm because I don't bring them junk information. Now, if you go to FBI NICS and ask them, you can literally be waiting years, and I call the circular file. You send them, or the client asks them why, and they will send you back a response. Well, you or someone like you may have been charged and convicted of something that bars you from firearms, and it lists the appropriate statutes. That doesn't tell a person how to fix it. It doesn't tell them what court. It doesn't tell them anything. There's no way a person will ever be able to buy a gun through the NICS system with those type of answers. And I sent out to the committee, and I'm happy to send the committee these samples of these letters. It's like a circular thing. It is a horrible, horrible thing for a gun owner. FBI NICS denies people their Second Amendment rights every day of the week. And it's just an exercise in futility. And those who hire me to do that spend tons of money. People who go through the gun line spend a small fraction and get their issues addressed literally in hours, if not days. So anyone that tells you that that's not the case, I've been doing this for over 20 years, and it certainly is the case. The gun line is really a protector of New Hampshire citizens' Second Amendment rights. But more importantly, if this bill was to pass, it's missing so many provisions. Again, I wouldn't have time to tell you about them. One of the provisions talks about an appeal. Well, how many days do you have to appeal to the Supreme Court? Show me where that is in the bill. It's not there. There's all these mechanical provisions that are necessary when enacting a bill. They're simply missing from this bill. And I think that's a huge problem. The other problem they've talked about is, for example, in this bill, a person's firearms are taken, but they can still have ammunition and ammunition components. That's pretty interesting. That's not how it works under federal law, but this bill simply doesn't address a lot of those issues. But the other issue is they talk about this 24 hours. Person's going to get updates of any modification or dismissal, prohibiting firearms ownership, and this is all found on page 3 of 5. But what if someone actually looks at the bill, you look at it and you say, wait a minute, the courts are not mandated. It says the court will update NICS. Why doesn't, I'm sorry, the court, it doesn't say the court shall update NICS. It also gives them 24 hours. Oh, sorry.
Excuse me, I do have to ask you to suspend the testimony. We do have some restrictions in time limit. And I believe your time has expired. However, I will recognize Representative Klein Knight to ask a question.
Thank you, Mr. Chair, and thank you for your testimony today, Mrs. Dean. I would like you to go through, for safety reasons for my New Hampshire residents, if we were to amend this bill and fix it, what are some of the other concerns that caught your eye?
I have a whole bunch, and I'd respectfully say that this should be ITL'd. I'm absolutely opposed to the bill because no matter how many fixes you put, you can't, or at least no one that I know, can control those in Washington, D.C. The bottom line is if we have a problem now with this, we can pick up the phone and go talk to the gun line. We can walk into the gun line. You can't do that with FBI NICS. You can't call a person who's a decision maker. You can't walk into their office. So if you start in the beginning to fix the bill, the first place that I would fix the bill is that, which is page 2, and I don't have the line numbers because I looked at the sections. It would be section 3, the 159.6D1, Roman 1, number C. Nothing in this chapter shall be construed to limit, prevent, or impose background check requirements on the private transfer of firearms not otherwise prohibited. That is an open the door to allow private background checks. That is just poorly worded. And I am a person who is opposed to private background checks, meaning if there's private sale of firearms, I'm opposed to that background check. This is an open door for that. So that's one thing I think would have to be fixed. Next, what about civil proceedings? They have a process there for those whose firearm was taken. Again, this is in the same section on page 2, 159D1 and Roman 2. They talk about order under 173B, 633B, criminal proceedings. What about any other civil proceedings? If you're involved in any of those other civil proceedings and your firearm is taken away, I guess you don't get it back because there's no process here. It's not listed in here. And any judge is going to say to you, the legislature means what it says and says what it means. If they didn't put it in there, it's not covered and I can't do anything about it. Next, if you look at that same page, which is page 2, Roman 2C. If the county sheriff's office determines that an individual is prohibited from owning or possessing, it says the specific facts relied upon. The specific facts are useless. You need a docket number, you need a court, you need a citation, and you need the why. Those are the things right now the gun line hands you on a silver platter virtually immediately. That giving that basic information should absolutely be required. And again, I can provide the committee form letters for years and years and years that the gun line gives those things. And so why wouldn't that be required here? Those are very basic pieces of information. If you go to page 3.
I may ask of the witness, I certainly appreciate the detail of your testimony. I understand there's several issues or concerns you have with this bill. There are other questions and other members of the public present, and we are already behind schedule. So, do you have written testimony that you can provide to the committee? Do you have it already?
I don't have written testimony, and I apologize. I thought I was answering the representative's question, so I didn't mean to go on. I was going through it.
You weren't answering the question, but from my understanding of your testimony, or at least answering the question, that your answer may, it was a fair question, but it's going to be a long answer. So I'm just trying to see.
I have a follow-up, Chair, if I may.
Not recognized for follow-up. I'll allow you to continue to answer the question.
I'm sorry. Do you want me to continue answering or wait for a follow-up? I didn't catch what you were saying, sir.
If you may continue answering the question, but I just am a reminder that we do have other members of the public, and I understand this concerns that you raised, and they're all valid. And
Chair, am I not recognized? I didn't quite hear you.
you're not recognized for a follow-up. The witness will continue answering the question.
Yes, sir. And I'm not going to answer every part of the defects because the chair has asked me to be brief. So I just want to let you know that I'm hitting the highlights, but not all of the defects. On page 3 of 5, the very first couple of lines, which is essentially Roman numeral 2D, 1, 2, and 3. It says the expiration of a deadline for filing a petition or notice of appeal in the trial court, and they don't give specifics. For example, you file a Rule 7 notice of appeal in the Supreme Court, but they're not giving you specific procedures and deadlines. So they have some for times in the trial court, but not in the Supremes. They talk about the appeals of denials in 159D2, which is also on page 3 of 5. And you have a right to request a further hearing on the matter within 30 days of the date of denial. That's suggesting there was a first hearing. When one says further hearing, it suggests there was a hearing prior to that. And it doesn't seem to be the case unless they're talking about the hearing where you ask for the firearms to be returned pending a sheriff's department check. The next error that I find is, like I said, it's in page 3 of 5, the ammunition or ammunition components used to be prohibited as well as firearms, and now they seem to be allowed, which is contrary to federal law. But I guess we're going to do things our own way here. The other thing we have here is it's going to take at least 48 hours for this to happen in some instances because the court has 24 hours. If they follow the situation where they send it to the Department of Safety within 24 hours, the Department of Safety then has 24 hours of receipt of this to upload it into NICS. That's 48 hours. But the other question is, in certain instances, does the legislature, under separation of powers, have the authority to mandate the courts?
I'm going to ask the witness to suspend answering the question. That the answers, we do have to move along. I do apologize. If we have additional time, I'll allow you to continue answering that question. There's other members that also have questions. So I'll recognize Representative Burke for a question.
Thank you, Mr. Chairman.
And try to keep the question direct and brief answers.
Yep. And thank you for taking my question. Over the last 20 years, we have seen ups and downs with the time it takes for a handgun to be processed for backgrounds. how are we gonna fix the future ups and downs if we continue with the current system with the state police?
Thank you for your question, Representative. Here is what I personally believe. I believe the state police had a rogue employee that was doing as they chose when they chose. This guidance from the Attorney General's office that I believe is dated, I want to say it's in January, but I know it's of this year, is very specific as to the checks, how they are going to be conducted and what's going to be checked. It has made a massive difference in what's done. So I believe, unless someone was going to suggest the employees just ignore the Attorney General's guidance, that things are fixed. I've talked to dealer after dealer who tell me 5 to 7 minutes is how long they're waiting for checks, because I, like everyone else, calls the dealers. So I believe that it is fixed. They had a problem. They've identified it. They've got rollover phone lines. So I know we can't guarantee anything, but I know people who wait longer on NICS. And I hope that's responsive. I'm sorry. I don't think anybody can guarantee anything, with all due respect.
Representative Burt, you're recognized for a follow-up question.
Thank you. And you spoke on how it's easier to fix a denial, a false denial in New Hampshire. Can you explain, because I'm hearing from the national groups that it is really easier to go to the feds and to fix this problem if you are denied? And can you, explain how the feds are different from the New Hampshire?
Absolutely. And what I'm also going to do after I finish testifying, Representative, is send the committee a bunch of redacted letters from both NICS and the state, and the proof is in the pudding. So let me walk through what happens when you're denied by NICS. When you're denied by NICS, if the person chooses to go online, they can input their information into NICS, and NICS usually comes back and says, we think you're a person that's prohibited under federal law. You have a name and or date of birth that's similar, but we have to be sure it's you. So, oh, by the way, give us your fingerprints. And so I'm thinking, okay, they were sure enough that it was him or her to deny them. You don't need fingerprints for a passport, don't need fingerprints for a driver's license, but they're going to demand your fingerprints. And they send you this circular letters. They'll send you the same letter 10 times in a row, but that will not tell you the court you were allegedly convicted in, the place you were allegedly convicted, and why, specifically why you're denied. Saying that you're denied under federal law because you may have been convicted of a crime for which you could have received more than 1 year imprisonment is not helpful. It doesn't allow you to solve the problem. I have one letter that's dated this year that I can send to the committee. And here's what the letter from NICS says. Even if you give us a criminal record check from the state this is from, certified, that says you have no record, it's not good enough for us. In this case, they claim person X was arrested on this X date for crime X. Well, person X has never been arrested ever for that crime, never been convicted, and they don't claim he was convicted. They say he was arrested. It's impossible to prove a negative. I have another letter that said, we think you were committed to a mental institution. If they think that, they should be able to tell you the date, the city, and the mental institution. But if you ask me today to prove that I wasn't arrested in Kansas City, I can't prove a negative, not by their standard. They will not accept even a state police clear record. There's no reasoning with them. It comes back to when my mother said, you can't have a cookie. And I said, why? Because I'm the mother and I said so. That's how FBI NICS operates. They simply won't give you an answer. And without an answer, you're never going to be able to buy a gun because they won't tell you why. They didn't say in Concord District Court in June 1944, docket number ABC 123, you're convicted of violating RSA, blah, blah, blah. That's a reason that the gun line's going to give you, and you can debate it. NICS will never do that, or rarely do that.
Thank you.
Yeah.
Question. At this time, we're not going to recognize any more questions for the witness, and the witness is excused. I want to thank you for your testimony.
Thank you, Chair.
question for the chair. Mr. Chairman, may I ask you a question?
I would prefer, it's the chair's preference to keep the hearing moving along. There's still members of the public present.
Point of order then?
You're recognized for a point of order.
I just, you gave Representative Burt a follow-up, and I had a very good question that I would have really liked answered on behalf of my constituents. And I just think it's, with all due respect, I should be allowed the same treatment as my colleagues across the aisle.
I understand what your point of order you're making. I don't believe that is an appropriate point of order, but I understand that you're dissatisfied with the discretion of the chair. I am trying to keep the hearing moving along. I believe that that's also in the interest of the public. The witness that previously testified is very easily accessible. If there's any information you wish to get from her, I'm sure that she's more than willing to speak with you. And I believe that that witness will also be present the following hearing. So accept my apologies. We will not be executing this bill immediately after the public hearing is closed. So you will be having time to ask that question.
Thank you, Mr. Chair.
Chair, at this time, recognize the camera.
Hi, good afternoon, Mr. Chair, members of the committee. Can you hear me okay?
You can hear me. Just a reminder, your testimony will be limited to 2 minutes.
Okay, thank you so much. I'll try to be as brief as possible. My name is Pamela Keilig, and I am the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. I'm here to speak in opposition to SB 141, which would eliminate the state's gun line and place victims of domestic violence and stalking at a heightened risk of lethal assault in New Hampshire. Thank you so much for the opportunity to testify today. New Hampshire's gun line, as you've heard, serves as a state backup registry allowing law enforcement in New Hampshire to conduct criminal background checks when individuals attempt to purchase firearms or petition for return of firearms after they have been legally relinquished due to domestic or sexual violence incidents. Domestic violence offenders are the most likely to murder someone in the state, so this system is crucial to protect the lives of victims. This system has been in place for over 20 years, and there are New Hampshire-specific public safety concerns that need to be addressed before we eliminate the gun line and shift entirely to the federal system. I also want to reiterate some of the concerns addressed by the Department of Safety and the courts in their testimony, which we share. The transition from the Department of Safety to the FBI will take a considerable amount of careful planning and coordination where all necessary stakeholders are engaged in this process. This conversation has not yet taken place, and it has not been confirmed whether or not the FBI can fully transfer New Hampshire's gun line into the federal system, which I think you've heard so far this morning. This means that we are gambling with the lives of victims. Specifically, I want to highlight that as written, this bill does not ensure the same level of protections currently afforded victims of domestic violence and stalking under New Hampshire law. As you heard from previous witnesses, this bill does not include all types of protective orders currently included in the gun line, and only authorizes very specific protective orders under 173B and 633.3. It excludes criminal bail protective orders and protective orders under the Child Protection Act, which is a very serious thing to exclude. Additionally, the NICS system would not search the emergency domestic violence orders and criminal bail protective orders issued after hours, further limiting the state's ability to adequately respond and ensure that violent offenders are not able to access deadly weapons. Secondly, you heard about the issue with protective orders that do not have the date of birth. So I won't go into detail on that, but I'd be happy to answer further questions if clarity is needed. But without the gun line, there will always be approximately 50 to 70 people with the ability to purchase a firearm that are legally prohibited from doing so. In conclusion, while shifting background check management to the federal government could work someday, the proper work and planning has not been done. And if the current legislation were to pass, there could be lethal consequences. Due to the serious concerns we have regarding victim safety, we are asking if you would please consider voting ITL on this bill or consider making this a study commission to grant us more time to make sure this system is properly vetted. Thank you so much for your time, and I'd be happy to answer any of your questions.
Thank you very much for your testimony. The chair now recognizes Representative Alschiller for a question. And just before you ask the questions, Representative Wallace was the timekeeper, and he's stepped out of the room. Will someone else take that responsibility? Representative, should you mind until you return? Thank you. Representative Alschiller, you recognize.
Thank you for taking my question. Ms. Keelig, could you go back into your testimony and, I'm sorry, could you just reiterate and clarify the 50 to 70 restraining orders or protective orders that would be missed by this? What would be the effect for those people who had taken out those restraining orders or protective orders that would be missed by this process?
Thank you so much for your question. This was what both Commissioner Quinn and Richard Head from the courts were highlighting regarding the cases where a victim filed a protective order but does not know the date of birth of the defendant. So that is that gap that they highlighted where they're between being able to file and get granted for the protective order and then getting the protective order served to the defendant, that without that date of birth, it would not be entered into the NICS system. So this is that 50 to 70 people are on average the amount of folks that would be missed in that gap. So who could legally get a firearm even though they're prohibited from it.
I have a follow-up, Mr. Chair.
Senator Walsh, you're recognized for a follow-up question.
Thank you. Ms. Keelig, we heard testimony today from Department of Safety Commissioner Robert Quinn, who said he's documented a 63% increase in gun sales. As a representative from the New Hampshire Coalition Against Domestic and Sexual Violence, can you speak to an increase in gun-related domestic and sexual violence?
Thank you so much for the question. I don't have any current data, but I will say from the 2018-2019 Domestic Violence Fatality Review report that came out in October 2020, we know that there about 40 to 50% of homicides in the state of New Hampshire are domestic violence related. So domestic violence was a factor in those homicides. And we also know that firearms account for about 50% of the causes of domestic violence homicides. So it is a significant concern. And that is why victim safety should be really central and considered when we're talking about changing our background check system. Thank you.
Seeing no further hands raised, I want to thank the witness for her testimony. The chair now recognizes Jeff Kelman, and just a reminder, testimony will be limited to 3 minutes.
Hi, can you hear me?
Yeah.
Excellent. So thank you so much for hearing my testimony today. I live in Bedford, New Hampshire, and I've just wanted to share a personal story, personal anecdote of my own experience. I've actually gone to buy firearms before, both long as well as handguns, and the experience that I had with buying a particular handgun. I have no reason to be denied or delayed or anything of that nature from any sort of criminal or civil basis, clean record in that regard. I went to go buy a handgun wherein I experienced a 5-week delay from the gun line on a particular handgun. And this was actually, I had bought more than one over the course of a particular year. So this was a follow-up that I had bought, and this particular gun was a single shot 380, little obscure, firearm. But the fact is that had I had malintent and been trying to do something harmful, I would have been better served going to a Home Depot and getting a hammer, frankly, at that point. But the fact that I had a 5-week delay, I think, just for this, and I've bought firearms both before and since, and seeing what's wrong really with this system, shows that, frankly, I would think about abolishing it even if it were free. But the fact that it also costs the state taxpayers money, I think it's just egregious, and I'd like to go on record there.
Thank you for your testimony. The chair now recognizes Representative Klein Knight for a question.
Thank you, Chair. Thank you, sir, for taking my question. So if you had firearms already in your home, this wasn't a need for protection, correct?
I mean, first of all, the fact that it was a single shot 380, as I mentioned, shows that, again, it's not really the lethal force of the tool that was of concern. I think the bigger concern is with the fact that what's the justification for that 5-week delay? Given, as I mentioned, there's no other reason for delaying me, and there hadn't been prior or since.
Thank you. Seeing no further hands raised, I want to thank the witness for his testimony.
Thank you.
If there's any members of the public who wish to testify that have not testified already, please raise your hand. The chair is going to recognize his Representative Maria Perez. And just a reminder, testimony is limited to 3 minutes.
Thank you, Mr. Chair, for giving me the opportunity to speak against SB 141. My name is Maria Perez. I'm the representative for District 23. I just want to be clear. I'm not against anybody having guns. I just want to make sure that people understand that I'm not against guns. But to be honest, this bill is a domestic violence survivor. It doesn't make me feel comfortable. It doesn't make me feel the confidence that our big thing getting protected by this bill. I feel like the language that I keep hearing from this bill, when people testify in support of this bill, is more they care about the money and they care about the gun owners. It's nothing about this bill that it says that, like, this is what we care. This is like the concern about the domestic violence victims. And for that, I will say, please vote no to this bill. Thank you so much.
Thank you for your testimony. Seeing no hands raised, Representative, you are excused. Is someone with a phone number? So I don't. Disappeared.
Oh, there is one phone number, Mr. Chairman.
Just please state your full name for the record. State whether you're testifying in support or opposition to the bill, and if you're testifying on your own behalf or on behalf of an organization. You testify for 3 minutes. At this time, the chair recognizes Alan Rice. And just a reminder, testimony will be limited to 3 minutes.
Yes, good afternoon, Mr. Chair, members of the committee. My name is Alan Rice. I am a resident of Bedford, New Hampshire, and I am here as a representative of Gun Owners of America. I submitted written testimony to the committee. You all should have a copy of it, and that will speak for itself. What I would like to direct your attention to is the back pages of my written testimony, where I have submitted to this committee comments from many grassroots gun owners and gun dealers who have experienced significant delays, not 15 minutes, not even 2 hours, but several days, weeks, and months with problems with the New Hampshire gun line. This is not a new problem. This problem has been going on for over 20 years. It's never been instant in New Hampshire. Never, ever, ever. A gun dealer would call, a clerk would take the information and say, we'll call you back. And the call back comes anywhere from 15 minutes to days, weeks, and in some cases, months. We have heard over the years the state police have tried to fix it. The fix works for a short period of time, and things revert to the old ways. The purpose of me submitting these comments is for this committee to hear from regular members of the public who have been burdened and inconvenienced and deprived of their Second Amendment rights because of these delays at the gun line. Enough is enough is enough. This committee should vote Senate Bill 141 ought to pass as submitted to you by the Senate. They heard the testimony, they heard the concerns of the sheriffs, they addressed the concerns and amended the bill. It's time to pass it. Thank you.
Thank you for your testimony. Chair recognizes Representative Burke for a question.
Thank you, Mr. Chairman, and thank you, Mr. Rice, for your testimony. Could you explain if a person is denied, if we only use NICS and not the New Hampshire State Police, how hard is it to fix that denial?
So, working for a national firearms organization, I have the ability to speak with people across the country. And as you have heard, the vast majority of states go through the FBI. They do not use a state point of contact. And when I talk to lawyers in these states, they tell me it is very easy to appeal a NICS denial. I'm not a lawyer. I've never represented people, so I haven't done it. But I go by what the attorneys tell me, and they tell me it's extremely easy. In many cases, a person can do it on their own. They don't need an attorney. But yet in New Hampshire, the system is so burdened and so complex, the person does need an attorney, whether it's some of the attorneys who spoke here earlier or somebody completely different, but they need an attorney. It's a complex labyrinth system, and it's extremely difficult. Where the federal system is very clinical, it's on the numbers, and a lot of it's done by mail. And it's usually handled in a very, very expeditious manner.
Just a small follow-up, Mr. Chairman.
Recognized for a small follow-up.
Thank you, Mr. Chairman, and thank you for taking my follow-up question. With the current system with the New Hampshire State Police doing backgrounds through NICS, are there any benefits to the New Hampshire resident or business for doing that?
We don't see any benefit. The initial system in New Hampshire was designed as an intermittent or an interval system when the Brady Wait in the mid-1990s required a gun buyer, a handgun only buyer, to wait 5 days between purchase and delivery of a handgun from a licensed dealer. And the only way to avoid the 5-day wait was if the state of residence had some sort of a permit license or check, which is why this was instituted. That 5-day wait went away on November 30th, 1998, when a national instant check system came online and also extended the check to rifles and shotguns as well as handguns. New Hampshire's law had an automatic sunset provision, but the state kept doing it for a year under what we believe is an illegal executive order. I've written about this in my testimony. And then a year later, they passed the law that we have now that allows the state police to be a point of contact. And quite frankly, not only has the law outlived its usefulness, the current law has far fewer checks and balances and protections than the law that it replaced in 1999. So no, there is no benefit to New Hampshire doing it. And there's a detriment. And the detriment is we are spending state tax dollars using state employees, state resources, state computers to perform a federally mandated task that the federal government will perform free of charge and in a more expeditious manner.
Thank you.
Representative Alshaw, you are recognized for a question.
Thank you. Thank you very much, Mr. Chairman. Thank you, Mr. Rice, for taking my question. In dialing back to your testimony, I want to ask, my question is that, excuse me, since New Hampshire does not have any kind of background check for private sales,
anything that's done with federally licensed firearm dealers, is it your testimony that that people are impinged or are unable to buy weapons because in one arena there might be a delay, but in another arena they can just go buy whatever they want?
Well, there's a two-part answer to your question, Representative.
Sure.
So you are correct. New Hampshire does not regulate the manner in which people sell their personal property. And neither does the federal government if they're not selling it as a business, if they're not engaged in the business of selling guns for profit. So if you and I were personally acquainted to one another beyond this TV screen, we could sell one another handguns and that would be legal. But many people that we hear from want a specific type of gun in a specific caliber in a specific color. And the only way to get exactly what they want is to go to a federally licensed gun dealer and say, I want that. And it's the gun dealers who are required to conduct these checks. And these checks, as I testified, are subject to massive delays. And so the dealer's business is harmed. The gun buyer has to wait. And we don't believe it's in any way a crime fighting tool, because if it was, the states that had significant controls with permits to just have a gun in your bedroom would have far lower crime rates than New Hampshire. And the opposite is true. The states with these government issued permission slips and restrictions and permits have higher crime rates and more violence than New Hampshire, like Chicago and New York. So we don't believe the system is a consumer fraud. We don't believe it works anyway. There's a ton of false positives. And in the specific New Hampshire state gun line, the delays and inefficiencies have gotten to the point where it needs to be abolished, disbanded, and drive on and let the feds handle it.
Follow up?
Representative Alshaw, you're recognized for a follow-up question.
Thank you very much. Mr. Rice, in the previous testimony, we heard from the New Hampshire Coalition Against Domestic and Sexual Violence. This particular piece of legislation leaves a hole in it where survivors of violence and victims of crime can further be exploited. Is that a concern at all to the New Hampshire Gun Owners Association?
Well, first of all, the organization is Gun Owners of America, and I am the New Hampshire State Director. To answer your question, I would encourage all of those survivors to buy firearms, seek out professional training, and take responsibility for their own personal safety and security. We should not hamper the vast majority of New Hampshire residents who do not commit crimes, who do not commit violence, and make them wait and be delayed because a small subset decides to become criminals.
Seeing no. Representative Hopper, you are recognized for a question.
A quick question. Thank you, Mr. Chairman. Thank you, Mr. Rice, for taking my question. Earlier today, we had a representative from New Hampshire Firearms Coalition testified against SB 141, and now you on their website are according to the NHFC website, you are the president of NHFC, and you're testifying for the bill. So I'm trying to understand the confusion.
I have not been president nor affiliated with NHFC since 2019. I work for Gun Owners of America, and for a period of time I was doing double duty because I have worked for Gun Owners of America since the mid-1990s.
Just a quick call. So their thank you, Mr. Chairman. So their website is incorrect?
I can't control the website of an organization that I'm no longer affiliated with.
Thank you.
Representative Bradley, you're recognized for a question.
Thank you, Chairman. Mr. Rice, so if I heard you correctly, you just stated that the turnaround time to obtain a gun is more important than protecting survivors. Is that correct?
That's not what I said.
Can
what
you
I said
clarify?
was I would encourage survivors to buy a firearm and learn how to use it and take responsibility for their own personal safety. And quite frankly, my organization finds it very objectionable that New Hampshire has more restrictions on the purchase, ownership, and use of firearms than those that are found in federal law in the majority of other states. And I'm specifically referring to the restrictions not on those convicted of domestic violence, not on those convicted of stalking, but those who are merely accused and subject to court orders. Those are not federal prohibitors. Those are mere accusations, and you should not lose your constitutional rights over an accusation.
Follow up.
Representative Bradley, you're recognized for a follow-up.
Thank you. So your solution to this is to put the onus of owning a gun on domestic violence survivors instead of looking at this as, I mean, this is just prohibiting, I mean, looking into this further, you want to put the onus on domestic violence survivors so you can have your guns in a timely manner.
What I said, Representative, is that if someone is a victim of violence, they should buy a gun, learn how to use it, and take responsibility for their own personal safety. Americans as a group are self-reliant, and if you become reliant upon government, you generally lose. People who have been subjected to violence, which is wrong, and we condemn it, should also take responsibility for their own personal safety. And as a firearms instructor, I have trained many victims of domestic violence. And when I have been told of what their case is, I usually give them private lessons so they don't have to sit in a large group and perhaps be uncomfortable.
Representative Klein Knight, you are recognized for a question.
Thank you, Mr. Chairman, and thank you, sir, for taking my question. So am I to believe that if a victim doesn't have enough time to buy a firearm, train themselves how to use it, and instead winds up murdered, it is their fault and they are being irresponsible?
I think you're over-sensationalizing, Representative. First of all, if they don't have enough time to buy it, it's because the state police gun line doesn't work. Second of all, it doesn't take an eternity to learn how to use a firearm. Third of all, the vast majority of people who obey the law and follow the law should not be delayed and have their rights hampered because New Hampshire has a more restrictive statute with respect to domestic violence accusations, not convictions, accusations, than the federal law. And we know from experience that defense and divorce lawyers use these accusations as a way to gain leverage in court proceedings. And oftentimes it comes out that they were lies anyway.
I have a follow-up, Chair.
You are recognized for a follow-up question.
Thank you. So earlier in your testimony, you said we should be relying on the federal government to do these background checks, but you just said that we're too reliant on the government and that you don't trust the government to do these background checks. Can you clarify your stance?
You're twisting my words. What I said was the New Hampshire gun line has proven that it's an inefficient system. It doesn't work. People have been forced to wait, in some cases, months to purchase a brand new handgun. The federal system, which checks the buyers of rifles and shotguns, has proven to be a very efficient system. People are approved in a matter of minutes, and they walk out with their new purchase. In general, we are opposed to background checks to begin with. But if we're going to have a check and we're going to be stuck with this federal mandate, why should we have a second set of bureaucrats at the state level and give them the ability to foul up a gun sale when one set of bureaucrats is bad enough?
Thank you, Mr. Rice. Seeing no further hands raised, I want to thank the witness for his testimony. At this time, the chair recognizes Lauren LePage. The testimony will be limited to 3 minutes.
Thank you. I will try to be incredibly brief because I know the committee's had a long day. Chairman Abbas, Vice Chairman Welch, and distinguished members of the committee, my name is Lauren LePage and I'm the New Hampshire State Director for the National Rifle Association. I am here to testify in strong support of this critical piece of legislation, and we want to extend our sincere thank you to Senator Gaida for putting this bill in. I've submitted written testimonies, so for the sake of brevity, I will just summarize it briefly for the committee. The vast majority of states are non-point of contact states, meaning that they use NICS for all of their firearm purchases. I believe the exact number is 36 states use the NICS system. And although it's appreciated the gun line has tried to increase efficiency in New Hampshire, it is absolutely no guarantee that the delays will not occur again. There's absolutely no excuse for justifying jeopardizing someone's right to self-defense because of a lack of government resources when the NICS system is readily available. This bill is simple. It authorized the FBI to conduct all checks, similar to most northeastern states, including Massachusetts, New York, Maine, Vermont, Rhode Island. It streamlines the background check system, it reduces delays, and it will save taxpayer money. And this bill is the only way to guarantee that delays will not return. On behalf of the thousands of members across New Hampshire, we strongly urge the committee to support this bill. I do just want to take a brief minute to respond to a question asked earlier by Representative Alschuler about how many new gun owners purchased firearms in 2020. According to the National Shooting Sports Foundation, approximately 5 million Americans bought their first firearm in 2020. That accounted for roughly 40% of firearm purchases for people who did not previously own one. So with that, I think I've hit all the high points in my testimony. Thank you.
Any questions? Done? Mr. Chairman, if you would like, I could call up Jake, is it Jake McWayne? Yep, McWayne. Yep.
Jacob?
No, it's Jake. I'll ask him. Yep, there he is.
Thank you. Appreciate it, Chair, members of the committee. My name is Jake McWiggin. I'm Managing Director for State Affairs for the National Shooting Sports Foundation. We are the trade association for the firearms industry. We represent manufacturers, retailers, ranges across the country. Two of our larger members are based in New Hampshire, being Ruger and Sig Sauer. Just to correct Ms. LePage's statistics, it's actually 8 million new gun owners. That's a more recent number. Of those 8 million new gun owners, 40% of them are female, and we've seen a 63% increase in African Americans purchasing firearms for protection in their homes. This has been quite a contentious hearing for the past 4 hours, and I appreciate everyone spending their time, sitting here. What I like to point out is that I think that every single person on this committee on both sides of the aisle should want to make sure that prohibited people are not gaining access to firearms. And what continued to come up in this, and from the trade association, the last thing our members want is for prohibited people to gain access to firearms. What people need to realize, though, here is we continue to talk about the domestic violence issue with the handgun and with the gun line. We know the gun line's broken. Without this bill, they wouldn't have come and tried to fix this, the gun line. It's been broken. People were waiting months for firearms. Our retailers could not conduct business, and they could not really, sell the firearms that they wanted to sell. But what we need to realize is that if all these records are being held in New Hampshire and in the courthouses and not shared with the federal system, individuals and victims of domestic violence will still be at risk because those individuals can buy long guns, meaning semi-automatic rifles and shotguns. How is that any different? They're still going to be at risk. What we want to do is, if it's such a big issue in New Hampshire and they have all these secretive files that they're not using, shouldn't those files be, and shouldn't we be using the NICS system? Again, it's only going to take a tragedy where individuals are going to have to point fingers at each other, and legislators are going to point fingers and say, well, how did this individual get this firearm? Very similar to the Manchester cops that were shot by an individual who should not have had that firearm. So again, as a trade association, we want it to be streamlined. We want it to be efficient. We support SB 141, and we also support those rights of domestic violence victims. But I think they are being exposed to really an issue because of the New Hampshire not sharing those records and the ability for individuals to purchase long guns because they're not using the gun line. Thank you very much. I'd be happy to take any questions for that. And I've tried to keep it short, so thank you.
Thank you, Mr. Chairman, and thank you for taking my question. In your experience nationwide with states that have, that go directly right to NICS,
and they don't go to their state police like we do. And then states like New Hampshire, where we buy a handgun, goes through state police, they go to NICS. What are the issues that you see that are different from the states of point of contact?
Representative Byrd, I appreciate that question. What we have seen in those states that have their own in-state systems, we have situations with delays. We have issues with staffing. We have some states out west that actually started to charge for background check systems in order to cover their costs. So essentially what it ends up being is a what we would call a poll tax or a Second Amendment tax on the purchase of a firearm. But what we've seen recently with COVID over the past year is that some states that did not recognize the firearms industry as having essential businesses, if they had an in-state background check system, they had the ability to shut down those background check systems. And then those individuals would not be able to, and our retailers would not be able to sell those firearms. More specifically, that would be New Jersey, which did that and did shut down their background check system, thus limiting the ability to conduct business. And then secondly, with budget constraints, we do see a lot of retailers impacted by furloughs or changing of hours. Many states don't keep retail hours. They'll do their background check system from 10 a.m. to 4 p.m. And obviously many people will go and purchase firearms after after work hours. So, and we're seeing that here specifically in New Hampshire because they are kind of controlling that gun line. And, obviously they're trying to say now that it's much, much more efficient and quicker. Again, without this bill, that wouldn't have happened, but it's only going to take another situation where they're going to pull back and have that. But the states that go to the FBI system, I mean, we're dealing with 2 to 3 minute, background checks. Obviously, you have to fill out your 4473 and do all that. But there have been in the past 10 years, the only outage of the NICS system lasted probably about an hour because of an upgrade to some software. So that would be the big difference that New Hampshire would be impacted by.
Follow-up, Mr. Chairman? Follow-up. Thank you, Mr. Chairman, and thank you for taking my follow-up. Have you seen any administrative abuse on check systems with the point of contact states?
We have. Most recently, some of our big box, and what I mean by big box is I mean a Cabela's or a Sportsman's Warehouse or Bass Pro Shops. Out west, specifically in the state of Nevada, there are two people answering phones in Nevada. As you can imagine with COVID, they've had, Las Vegas has been completely decimated from a revenue standpoint, which obviously is impacting the state budget. So we have large big box retailers that now have one dedicated person on staff whose job is basically to call in or continue to redial to call into the state in order to get a live person and then have a stack of forms to conduct that background check. They'll have, be waiting on 40 or 50 of them. So those are the types of abuses we see because again, the state's paying for it. It's a budget impact. And if they have budget constraints, they start changing the hours, they start furloughing, or they just, aren't answering calls. We never see that obviously on the federal system. I've been to the NICS system in Martinsburg, West Virginia, an amazing facility. Great people there. They do a great job and they can turn around background checks in less than 2 to 3 minutes and background checks that our retailers can be confident in. Again, our retailers want to make sure that when they sell that firearm, it's not going to a prohibited person, right? They don't want a knock on their door 2 days later after a horrific tragedy saying, why this gun, you sold this firearm. And they're basically in the media spotlight because of that. So our guys just want the confidence that when they transfer a firearm, it's going to be done right, efficiently, and they can be confident in it. Thank you.
Thank you. Thank you, Mr. Chairman.
Doug Mills has a question.
Yes, thank you for taking my question. You represent a gun manufacturers trade association, and you say that 8 million guns were sold across the country last year. I'm curious what the economic impact of the delays, specifically of the New Hampshire gun line, what that has been on manufacturers like the ones you represent.
Yes, thank you, Representative Muse. The statistics actually is 8 million new gun owners. That's not total number of guns sold in 2021. It is a bit of a hardship on our guys, because if we look at it from the federal standpoint, right? Let's assume a consumer comes in and fills out the 4473, which is the form that everyone has to fill out. It's a federal form when you purchase a firearm. And you end up, the delay ends up being 2 months. Okay. Well, that 4473 is only good for 30 days. Okay. Based on federal law. So it puts our retailers in a bit of a situation, because now you basically have to go back to the person that wanted to purchase a firearm, have them redo the 4473 and start the process all over again. So the concern becomes is, I probably should not, I won't say the state, but a state that does do their own background check system, and they were having probably 4 to 5 week delays, told our retailers in this specific state, oh, don't worry about the 4473 expiring, you can still transfer that firearm. I mean, and that puts our retailers' license, their federal license, on the line. So the economic impact, I would say, it unfortunately just, it slows down the course of business. The New Hampshire retailers are not, I mean, I'm based in both, I've been based in Connecticut and in Massachusetts, and both states use the federal system, and both states are very efficient. And compared to New Hampshire, I wouldn't say that they're very comparatively pro-gun states. Thank you, Representative.
Follow up, please. Yes. What I'm wondering is, it sounds like there have been some inconveniences to manufacturers, maybe a little bit of lost money. The situation that the state police are trying to avoid through the current system seems to be one of preventing people from actually falling victim to domestic violence. So I'm curious what your industry's stance is on protecting people from domestic violence. Is the answer just as simple as getting as many women in that situation as possible to buy guns, or do you think that government actually has a larger role to play in the process?
Thank you, Representative. As I mentioned in my testimony, I think it's being disingenuous to say that the gun line is protecting domestic violence survivors. Reason why I say that is because if an individual, and let's look at the national level, right? What do we keep hearing about? We keep hearing about quote unquote assault weapons bans. Okay. So if we hear about assault weapons bans, well, that usually will be impacting modern sporting rifles. So what is the one firearm that a person in New Hampshire that allegedly is in these in-state systems can go and purchase and pass a background check? And I'll answer the question. That would be a modern sporting rifle or a shotgun. So the state of New Hampshire is not doing anything to protect domestic violence victims with the gun line, because that individual, if they want to commit a crime and they are not, those records are not being shared with the federal system or with NICS, they will simply go in and purchase a long gun. And I'm not saying specifically in New Hampshire, because federal law says as a resident, you can go and purchase it in Vermont. You can go and purchase it at, in Maine. So again, I sat here along with everyone else here for over 4 hours hearing about this domestic violence and how New Hampshire is protecting those victims. They are not protecting those victims. I'm sorry, they are not. Now, do I agree that maybe, a domestic violence victim should make a decision and want to get training and get a firearm to protect themselves? That's entirely up to you. That's entirely their choice. But to continue to say that New Hampshire is protecting domestic violence victims is patently false.
Representative Newman.
Thank you, Mr. Chair, and thank you for taking my question. We have a single point of contact now with the state, and now we're going to.
The representative muted himself.
Rep. Newman, you muted yourself.
What happened?
Okay, let me try one more time. We have one point of contact in the state right now, and this bill would have points of contacts in all of the counties in the states, however many there are. What makes you confident that going through the counties will be more efficient and have less delays than going through just the state?
Excuse me. Thank you, Representative, for the question. Again, if the counties or the state are doing their jobs correctly, we wouldn't be having this situation, right? If the state was efficient in running a gun line correctly, but again, you're doing a double process. It's already a taxpayer funded, NICS is already a taxpayer funded system. And I would hope, but we do run into this issue elsewhere, and we've run into this issue in numerous states where the court systems or the states themselves are not sharing the appropriate records with the federal system or with their own internal state system. So the less bureaucracy we can get probably would be better, but I would hope that these court systems and these county courts would be sharing those records. That's no different. Let's look at it this way. It's no different than a felon, right? I would hope beyond belief that they're sharing, that those are convicted of felonies would be sharing those records from the county courts or from the state. And if they aren't, then we're in a very, very difficult situation.
Follow up. I guess my confusion is we say that the gun line's not working, but for the long guns, it works. Why is this bill better than doing it exactly the same way we do long guns, or am I just confused about what's going on?
With all due respect, Representative Newman, that's exactly what this bill would do. It would be make the gun lines exactly the same as long guns.
Thank you.
Yes, sir.
Representative Alto. You're muted. Okay.
Chair, thank you very much. And thank you, Mr. McGoran. I'm sorry.
It's okay. McWiggin is fine. Or Jake. Don't worry.
McWiggin.
Thank you.
McWiggin. Appreciate it. Thank you for the correction. I just want to dial back to some of the testimony that you just gave, or perhaps the answer to a question that you just gave about domestic violence, because it really is a big concern for this particular piece of legislation. And I'm wondering if you were familiar with the New Hampshire statistics. I know you gave us some national statistics, but did you know that in New Hampshire fatality review, 9 out of 10 domestic violence homicides are caused by firearms, and those are handguns. And so 50% of the firearm deaths, of that, only 1 in 10 are caused by long guns. So we really do want to make sure that we are not creating a massive loophole that victims will fall through.
Representative, I appreciate that question, but as you know, if somebody is bent on committing a crime, and let's assume that the gun line was not doing its job or vice versa, they're going to find other means to commit it, commit the crime, unfortunately. I do point to many of the statistics from the Department of Justice on the federal level dealing with criminals, right? I mean, if you're going to be a criminal, you are more than happy to see, further gun control policies put into place, because it's going to limit those, law-abiding citizens to exercise their rights. So yes, if let's assume there is an individual where the gun line does stop that domestic violence from happening, then that person would go to the next store and buy a rifle or a shotgun, unfortunately. And if the stats that you are saying are correct, that 9 out of 10 in New Hampshire, then obviously the gun line is not working, because they should have already been denied their purchase of their handgun if they did have temporary restraining orders. So 9 out of 10 crimes would not be committed with a handgun. So it's not working. Thank you.
Seeing no further hands raised, I want to thank the witness for his testimony. You are excused. At this time, the chair recognizes Paul Marquise. Just a reminder, testimony will be limited to 3 minutes. Mr. Marquise, you can unmute yourself.
Yeah, I just got off. I just finished.
Right. So, if there's any members of the public who have wish to testify, not testified already, at this time, please raise your hand. There is a phone number. If you wish to testify, just please identify yourself, whether you're testifying in support or in opposition to the bill, and whether you're testifying on behalf of yourself or on behalf of an organization. And your testimony is limited to 3 minutes.
Good afternoon. This is Jay Simpkin calling. Can you hear me?
Yes, we can hear you.
Excellent. I am a federally licensed firearms dealer, have been so in New Hampshire since mid-1993. I represent myself. Rarely have I heard so much mis and disinformation in one hearing as I have heard today. I can't possibly in 3 minutes address all of the errors, but the representative from the NSSF is categorically wrong when he said that, quote, a 4473 is good for 30 days. If a person fills out that form and is called away from the dealer calls and gets an approval. That approval is good for 30 days. But if the dealer never calls in the request for a background check, the contents of that form are valid until the dealer calls it in. So therefore, if a person fills in the form and leaves and goes off for months and months, and the dealer doesn't call it until the person returns, what's on the form is perfectly fine. There's a specific box on the form to be filled in. If once an approval is received, there is then a delay in the turning over of the firearm. Then the person has 30 days after the dealer calls it in to come back to the dealer and complete the transaction. A couple of other issues I'd like to address. I will send in testimony. At the end of 2018, according to Department of Justice statistics published in Firearms Commerce in the United States, there were about 423 million firearms in the U.S., excluding military items. The idea that has been suggested to you that if someone is denied they do not get a firearm is simply wrong. There are so many firearms available that a person who is determined to get one and who is denied will get one. They just won't get one from a licensed dealer. Now, turning to the core issue at hand. Only those who believe that the Commissioner of Public Safety is a liar and a cheat would have the gall to state to you that if it weren't for this bill, this would never, the long delays caused by a rogue employee would never have been fixed. Not so. I think Commissioner Quinn is a truthful man, and therefore the improvements to the process that have been made will be lasting. The concept that FBI NICS is bulletproof is wrong. I will send to you a copy of an email that I got as a dealer from FBI NICS on 19 March 2021 saying that because of the volume of clearance requests, you will encounter delays when you call FBI NICS. I'll call it the firearm feeding frenzy goes on at a slightly more moderate pace than it did in 2020, where FBI NICS approved, or at least processed, 39.7 million requests, a 40.3% rise over 2019. For the first 3 months of 2021, the number of requests is 36% up on 2020. And these are data released by FBI NICS. They release them every month. So in short, FBI NICS is not bulletproof. The other thing that you were not told is that for those who have a security clearance or have had a security clearance, they will often be delayed by FBI NICS if there is not at the FBI NICS center a person with a security clearance sufficient to allow them to look at the records of someone who, say, was a SEAL or a member of Delta Force. The first line agents at FBI NICS Center, and by the way, these are contractors, these are not government employees, cannot look at certain records. So after 20 years of war in Southwest Asia, there are more Americans, and by definition, more New Hampshire residents, who have held security clearances and who are more likely to get delayed by FBI NICS. The state of New Hampshire does not delay such persons because the folks who do these background checks are state of New Hampshire employees. We presume them to be honest and upright, and they mostly are, and therefore they can look at all of the relevant records. One point I'd also like to address is that for victims of domestic violence, there seems to be an assumption that they are somehow entitled to protection. This is not U.S. law. Here's the law in the words of a federal circuit court. But there is no constitutional right to be protected by the state against being murdered by criminals or madmen. It is monstrous if the state fails to protect its residents against such predators, but it does not violate the Due Process Clause of the 14th Amendment or, we suppose, any other provision of the Constitution. The case is Bowers versus DeVito. The legal site is F2D, Federal 2nd, 686, page 619. My point is, those who have been victims of domestic partners who are violent should not look to the state because they do not get.
Mr. Simpkin, we are limiting testimony to 3 minutes per witness, so I will ask you to conclude your testimony at this time. Seeing no further hands raised, I want to thank Mr. Simpkin for his testimony. I believe Mr. Jeff Kelman already testified, is that correct?
Yeah, I think Governor Less is Paul.
This time the chair will again recognize Paul Marquise. Just a friendly reminder, your testimony is limited to 3 minutes.
I just simply want to say that as long as the dealers are given a choice between the NICS and the directly to the NICS and the state gun line, there would be no issue. As it is, abolishing the gun line is not sustainable. That's all.
Good. Thank you. Is the answer? He's on the list. This isn't opposed.
Yeah.
Thank you for your testimony. Seeing no further hands raised, I want to thank the witness for his testimony. Are there any members of the public who wish to testify that have not testified already? Is that 359 number?
Yeah, I see 35 and then Jeff Kelman.
Jeff Kelman already testified.
Oh, he did, okay.
Did 359 number already testified?
Yeah, that's Jason.
Okay. Seeing no members of the public with their hands raised, at this time, we will now close the public hearing on Senate Bill 141. At this time, we will now open the public hearing on Senate Bill 154, an act prohibiting the state from enforcing the presidential executive order that restricts or regulates the right of the people to keep and bear arms. Again, with the exception of the person or the member who introduces the bill, will be limiting testimony to 1 minute per person testifying. And of course, members are limited to 2 questions per witness. Is there a senator present or a representative present to introduce the bill? Senator 154. Would a member of the committee just be so kindly to simply just introduce the bill, nothing more, and that. The chair is recognizing Representative Chris True to just introduce Senate Bill 154.
Thank you, Mr. Chair, members of the committee. For the record, I am Representative Chris True, Rockingham District 4, representing the great towns of Auburn, Chester, and Sandown. Thank you for this opportunity, Mr. Chair, to introduce Senate Bill 154, an act prohibiting the state from enforcing a presidential executive order that restricts or regulates the right of the people to keep and bear arms.
Thank you, Representative True. If there's any members of the public who wish to testify at this time, please raise your hand. And again, testimony will be limited to 1 minute. At this time, the chair recognizes Jeffrey Shing. Mr. Marquise, who waited so patiently to testify after a very long hearing, how about we give Mr. Marquise the courtesy of letting him testify on behalf of Senate Bill 154 right now?
What's his first name?
There he is. Oh, you got him. Thank you for your patience. The testimony is limited to 1 minute.
This is Paul Marquis representing myself and New Hampshire Firearms Coalition. In regards to Senate Bill 154, I'd like to say that we support the bill as it. We do not support the bill as it is written. And would suggest that an amendment be made that would include protection from federal laws that are passed regarding firearms acquisition and possession in the state of on the federal level, that state resources would not be used to enforce those laws. That's all.
Thank you again for your testimony. Seeing no hands raised, the witness is excused. Mark Polinsky. Chair now recognizes Joe Hannon.
Good afternoon, Mr. Chairman and members of the committee. My name is Joe Hannon, and I'm the Vice President for Gun Owners of New Hampshire, and I stand in support of this bill as amended, of SB 154. You know, we know that executive orders are written as directives from the President of the United States that manage the operations of the federal government. They don't have a mandate on state governments and what their agents are supposed to do. He's not the chief executive of states' governments and officers. Congress and legislatures can pass legislation that can make it difficult or even impossible to carry out that order. The federal level, they can remove funding in the Congress. At the state level, they can forbid or prohibit members acting as agents of the state from following those directives or regulations that are imposed by executive order. Recently, there was an opinion done about the bump stock ban that our former president had issued an order to direct the ATF and ATFE to ban the possession of bump stocks. Well, it was upheld in several lower courts, but the Sixth Circuit in Michigan ruled last month that they were not able to arbitrarily or unilaterally rewrite their own rule because they thought it was unconstitutional. It's not they said that it is not the role of the executive branch to dictate to the public what is right and wrong. The judgment is reserved to the people through their duly elected representatives in Congress. So I think that the states not following executive orders at the federal level, which are not intended for them to follow anyway, is not only necessary, but it's a reasonable decision that is sending a strong message that we will not comply in New Hampshire with arbitrary orders that are not passed through Congress. Thank you.
Thank you. Thank you, Mr. Hannon. Seeing no hands raised, I want to thank the witness for his testimony. At this time, the chair will recognize Dina Romero.
Good afternoon. Can you hear me okay?
Yes, we can hear you. And we apologize that we're behind schedule.
That's okay. I know the previous bill people had a lot to say. Thank you for allowing me to testify. I'm opposed to this bill, and I would like to tell you why. And I also want to clarify, I'm coming to you as a member of the public, as a mother, as a grandmother. And yes, I am a resident of Hanover, but I hope you will not disqualify what I have to say because I come from a very liberal town. So here are the points I'd like to make about this bill and why I'm opposed. I think we need to clarify some of our assumptions behind what we're talking about. So I'm clarifying, owning a firearm is absolutely your right. The issue here is not about owning a firearm. It's not about the Second Amendment right. The issue is gun violence in this country. So the goal of any federal legislation or presidential executive order on firearms is to reduce gun violence. If we only focus on the right to bear arms, then we are not doing anything about preventing gun violence and the mass shootings that have recently occurred. I find that very puzzling. SB 154 takes issue with any executive order on firearms issued by the President of the United States. Yet HB 307, I know that's not an issue at the moment, HB 307 takes issue with local schools or municipalities making a decision on firearms because we're not a home rule state. So does this mean that the state of New Hampshire will be the only entity that can rule on firearms in the Granite State? Do we pick and choose who makes the decision, who has the authority to make the decisions on firearms? I, for one, don't want firearms in the school. My final thought is instead of having this discussion about gun owners' rights, why can't we just join forces and work together and find ways to reduce gun violence? I really appreciate your time. Thank you very much.
Thank you for your testimony. Seeing no hands raised, the witness is excused.
Thank you.
Is Brad Cleveland, is he, can you hear us? If the committee researcher can hear us, on the Zoom video, it still says Senate Bill 141. That could be updated, so there's no confusion. At this time, the chair recognizes Dr. Leonard Korn. Thank you for your patience. Mr. Korn, you are recognized to testify. You need to unmute. While that's being worked out, the chair will now recognize Aaron Pinkisek. Aaron Pinkisek. This time, the chair will now recognize Xander Rice Hawkins.
Hi, can you hear me?
Yes, we can hear you.
Great. Please ignore the Moana music downstairs from the kids. My name is Xander Rice Hawkins. I'm the director of Gun Sense New Hampshire, a project of Granite State Progress. I'm here today to testify in opposition to Senate Bill 154. Let's be honest, this bill is not about protecting Second Amendment rights. It's about preserving the corporate gun lobby's ability to increase profits off the murder of American families. Mass shootings fill our news cycle each week, and we shake our heads, and some of you have the audacity to offer thoughts and prayers instead of concrete action. Now the Biden administration and leaders in Congress are working urgently to save lives, and the response by some New Hampshire politicians is to find ways to block, stop, and delay those efforts, even though it will cost lives, and even though we should all be able to agree that our families shouldn't have to live in fear of going to the grocery store, or to work, or to school, or to the movie theater, or to a health clinic, or a bowling alley, or walking down the street in our community, or playing in the park, or living in our homes, because dangerous individuals can easily access firearms and shoot and kill our families. Let's set aside for the moment that Senate Bill 154 and the proposed amendment are likely unconstitutional, that it could cost New Hampshire to lose hundreds of thousands of dollars in federal grants and aid, and that it is completely absurd to block public safety laws. Here are some of the things that this bill proposes to stop. The Biden-Harris administration has directed the Justice Department to issue a proposed rule to help stop the proliferation of ghost guns. As more criminals buy kits to assemble firearms in as little as 30 minutes to commit crimes that cannot be traced to the weapon, this proposed rule will help stop the proliferation of these firearms. They will issue a proposed rule to make clear that devices marketed as a stabling brace, like those purchased by the shooter in the Boulder mass shooting, are subject to the National Firearms Act. They'll publish model red flag legislation for states that will make it easier for states to adopt red flag laws, which allow family members or law enforcement to petition for a court order temporarily barring people in crisis from accessing firearms if they are a danger to themselves or others. These are the types of measures that we would always hear would have been helpful before a mass shooting. The Justice Department will issue an annual report on firearms trafficking. New Hampshire is a net exporter of crime guns. They're looking at evidence-based community violence interventions, improving strategies for reducing gun violence, and funding to help with those community violence interventions. Does Governor Sununu and this legislative body want to turn down federal dollars that could benefit New Hampshire from this source or others?
Ms. Hawkins, we did limit testimony to 1 minute per person. A lot of people signed to testify have appeared to have not been able to stay, but I am going to ask you if you can just wrap up your testimony. Members will be permitted to still ask you questions. You may conclude your testimony.
Thank you. SB 154 would also jeopardize public safety in other ways, preventing state work with ATF, the Department of Justice, or the FBI. A couple of examples here. Would New Hampshire law enforcement not be permitted to cooperate with DOJ investigations on extremist white national groups or militias in the state when firearms are involved, creating further harm for Granite Staters of color and others targeted by hate crimes? Would it limit the ability to hold accountable Granite Staters who participated in the violent insurrection in Washington, D.C.? Governor Sununu famously had to cancel his public inauguration earlier this year over fears of armed protesters, just months after an armed militia in another state hatched a plan to kidnap the governor of Michigan. Yet Senate Bill 154 could prevent the state of New Hampshire from...
Ms. Hawkins, you do have to conclude your testimony. However, Representative Muse, you are recognized to ask the witness a question.
Thank you, Mr. Chair, and thank you for taking my question. One of the things you mentioned earlier in your testimony was the fact that there are some things about this particular bill that may not pass muster from a constitutional standpoint. And I know that's one of the things I think a lot of people are interested in is, does a state like the state of New Hampshire actually have the power to basically say, we're not going to do that if Congress passes a law or the president signs an executive order?
Ms. Hawkins, you are muted. Please unmute yourself.
Thank you. That just came through. It's an excellent question. I think that this proposal has a lot of reasons why it would end up in a lawsuit, costing the state of New Hampshire a lot of money. And at the same time, it would really prevent our state from upholding public safety laws that we do have on the books, or accessing federal grants, or participating in really important conversations across state and federal agencies.
Thank you.
Representative Muse, do you have a follow-up question?
No follow-up. Thank you.
Representative Alshaw, you are recognized for a question.
Thank you very much, Mr. Chair. Thank you, Ms. Rice Hawkins, for your testimony. I'm wondering about the effective date. Like, how would this impact the state of New Hampshire if it were to go into effect immediately?
It's a great question about the enactment date. We did notice, we understand there's an amendment, and in the amendment, we saw that it removes the enactment date, which leads us to wonder whether or not those putting that forward are actually looking to have any kind of retroactive effect on any arrests or sentences that have already taken place. And we do wonder if it could result in appeals that would lead to convicted criminals being released.
May I have a follow-up, Mr. Chair?
Representative Alshaw, you are recognized for a follow-up question.
Thank you very much. Ms. Rice Hawkins, what kind of impact, who will be impacted by this? And can you tell me, like, what would happen to armed militias in this state that have coalesced?
Thank you very much for asking that, because armed militia activity has been growing across New Hampshire, as well as white supremacist activity. It's something we're very concerned about. Our organization has been raising the alarm on it for over a year now, and you saw that really come to a head around some of the activities down in DC with the violent insurrection, as well as Governor Sununu, as I mentioned, having to cancel his public inauguration earlier this year over fears of armed protesters. This is a very real situation, and a policy like Senate Bill 154 could really limit the ability for us to proactively address, or in the unfortunate circumstances of activity that happens, hold accountable those bad actors who are threatening Granite Staters and our public leaders. And then in terms of who this would affect or impact, one of the things that's true about Senate Bill 154 is that it does cast a really wide net. It would prohibit state and local police, but also judges, prosecutors, other state actors from enforcing, administering, or cooperating with any federal law, act, rule, order, regulation if the state of New Hampshire doesn't have those specific laws in place. I think it would be really beneficial for this committee to ask prosecutors, members of law enforcement, the judicial body, how they think that this would impact them, both in terms of the work that they already do, the cooperation they have across state and federal agencies, as well as any grants that they receive from the federal level to do the work to keep our community safe.
Seeing no further hands raised, I want to thank the witness for her testimony. At this time, the chair will recognize Tracy Hahn Burkett.
Thank you. Tracy Hahn Burkett, and I'm here on behalf of myself and as the leader of the Kent Street Coalition's Working Group on Gun Violence Prevention. I'm testifying against SB 154 because people are dying from gunshots in this country every single day. It's not just a few, it's nearly 40,000 people a year. And we see it on the news all the time. We're no longer surprised to learn of mass shootings. These reports are only slightly less regular than the sports and the weather reports. Children today do not regard being shot at school or elsewhere as something that probably won't happen to them. Now, it's true that New Hampshire does better than most states, but more than 150 people died here by gunshot in 2019, to say nothing of those who were shot and survived. We can do better if only we choose to. Now, given Congress's inaction in this area, the Biden administration has chosen to do something via executive order, a means of governing that was just fine with the current New Hampshire majority party until, as it says in the bill, January 20th, 2021. The planned amendment would, for example, I also want to speak against the amendment that we know is planned because it seeks to remove from the people of New Hampshire any and all protection that may be offered to them by the federal government, which would mean for some people, and in some cases, a matter of life or death. It seeks to divorce the people of New Hampshire from the functions of the United States when it comes to matters of firearms, knives, and related items. And just to provide an example, if one of the frequent mass murders of 2021 were to occur in our state, such that the FBI's assistance was warranted, this amendment would make it illegal for any New Hampshire law enforcement or other official to cooperate with them. And New Hampshire law enforcement would likely not be able to cooperate with federal agencies on investigations of extremist white nationalist groups or militias in the state, particularly when they are led there via firearms-based incidents. And of course, that could have a disproportionate negative impact on New Hampshire people of color. So just to sum up, people want the overall bloodshed to stop. And this bill is explicit in its intent to protect firearms, but nowhere does it mention any desire to protect people. And so I would just urge you to vote to ITL SB 154.
Thank you for your testimony. Seeing no hands raised, the witness is excused. The chair will now recognize Alan Rice.
Good afternoon, Mr. Chair, members of the committee. Alan Rice again with Gun Owners of America. I did submit written testimony of our support for this bill. When I drafted my written testimony, I was under the mistaken impression that there was an amendment from the chair and Representative Burt. I've been later informed that there's an amendment just from the chair. I want to state that either amendment is acceptable to Gun Owners of America. We're very much in favor of the concept of not using state and local resources to enforce federal laws. The federal government, they're going to do what they're going to do. They can pass whatever laws they're going to pass, and there's federal law enforcement agencies to enforce them. The state, everyone knows New Hampshire operates as a lean state with a lean budget. We pride ourselves on, New England frugality. And we clearly should not be using state and local resources to enforce federal gun laws. We do empathize with some of the previous speakers. We're not in favor of the violence. We're not in favor of the bloodshed. We're not in favor of any of the things that are going on around the country at this time. But we disagree. We disagree because if there were to be such an incident in New Hampshire, there's plenty of state crimes that New Hampshire law enforcement could charge a murderer with. And there's nothing that would prevent New Hampshire law enforcement from collaborating with FBI or ATF in the case of true criminal activity. This bill doesn't prevent that. What it prevents is the cooperation by state and local law enforcement in wholesale gun confiscation, harassment of legitimate licensed gun dealers, harassment of legitimate firearms owners who have done nothing wrong other than perhaps assembled a firearm at home, which is something that's been done for over 200 years in our republic. And rather than go on, I'm going to refer to my written testimony and urge the committee to adopt either the Representative Abbas amendment or the Representative Abbas-Burt amendment and vote the amendment, and Senate Bill 154 ought to pass. And I will entertain questions if any representatives are so inclined.
Thank you, Mr. Rice, for your testimony. The chair recognizes Representative Pantelakis for a question.
Thank you, Mr. Chair. Thank you for taking my question, Mr. Rice. Could you tell me how many members you have in your organization?
We have over 2 million members and supporters nationwide.
In New Hampshire?
In New Hampshire, it'd be close to 10,000.
Thank you.
At this time, the chair recognizes Representative News for a question.
Thank you very much, and thank you for taking my question. The Biden administration recently announced an executive order that would ban ghost guns. And I guess my question to you is do you think ghost guns present an issue in terms of gun violence? And is the proliferation of ghost guns something that your organization would support?
Guns are not violent. Guns are inanimate objects. Guns are no more responsible for violence than the automobile that was driven by the murderer in Charlottesville, Virginia, and we don't refer to it as automobile violence. There is no such thing as a ghost gun. Guns are not invisible. What I believe you're referring to, Representative, is firearms that are home built and home assembled. That is an activity that has gone on since before the founding of our republic. We endorse the activity. We support the activity. We do not agree with banning the home assembly of firearms for one's personal use in any way, shape, or form.
Representative News, you're recognized for a follow-up question.
Sure. So just so we're crystal clear, you have no problem at all with ghost guns?
I have no problem with people home assembling firearms for their own personal use.
Thank you.
Representative Altshuler, you are recognized for a question.
Thank you very much, Mr. Chair. And thank you very much, Mr. Rice, for returning and taking my question. My question is that you just mentioned that you support the amendments. I only have access to one of the amendments, and I'm curious, are you aware in the amendment that it says that the state of New Hampshire or any public political subdivision of the state or any person acting under the color of state, county, or municipal law shall be prohibited from using any personnel or any financial resources to enforce, administer, or cooperate with any law, act, rule, or order or regulation of the United States government or executive order of the president. So it actually does very specifically state we would not be allowed to participate with the FBI or the CIA or any other federal agency that were to come to New Hampshire to assist with
There are questions on it?
So did you understand that when you said you supported this amendment?
The amendment that I read, let me pull it back up so I can follow along, talked about laws and rules specifically with respect to firearms.
Right, 19 through 21, are we looking at the same thing?
Let me pull it up right now.
And Mr. Chair, with respect, I understand that this amendment has not been introduced yet. And
But you've asked the witness, let the witness respond to your question once he is able to review the materials. If you wish.
Yeah, my question was for you, Mr.
Representative,
Chair.
what page and what line, please?
Just to clarify, excuse me, Mr. Rice, I'm so sorry. I'm sorry, I'm looking for some clarification from the chair.
Can I just explain to you that you asked a question to the witness, so I'm going to repeat myself. I want the witness to respond to your question. If after the witness responds to your question, if you wish to make an inquiry of the chair, you may do so. But I don't want there to be two conversations happening at once. So please allow the witness to answer the question that you just previously asked.
Okay, thank you very much. So yes, Mr. Rice, on the Abbas amendment lines 19 through 22. So my question was, are you agreeing, is your organization, Gun Owners of America, agreeing with that amendment?
Yes, I think you left out the second half of that amendment that says with respect to firearms. I'm not going to read the whole thing. We all have a copy. It doesn't say forbid cooperation with the federal government on things other than firearms. This is very narrow with respect to firearms. And yes, I stand by what I said a moment ago. We support the amendment offered by Representative Abbas.
Okay, may I follow up, Mr. Chair?
Yes, and Representative, if you are referring to an amendment, it may be helpful to reference not just the sponsors, but perhaps the amendment number. So just so members of the public or the witness and members of the committee are clear on which amendment you're referring to.
Yes, my apologies. So sorry. The amendment was just referring to is Amendment 1220H, introduced by you, Mr. Chair. Dated 4/05. So that was the amendment that we were just referring to.
Thank you.
And so my follow-up question to Mr. Rice, if your concern is around violence, as you have testified, do you think we should pass any laws that around who could access firearms, what type of firearms, or both?
No, I think we should repeal the laws that prevent people from easily accessing self-defense firearms. I'm sorry, it said I was muted. Can you hear me now?
We can.
I'm sorry. I said I think we should do the contrary. We should repeal the laws that make it difficult, inconvenient, and expensive for law-abiding people to access self-defense firearms. I think people have an absolute right to defend themselves. And if you look at New Hampshire and Maine, with our very gun laws that allow people to actually defend themselves in comparison to places like New York and Chicago, where that right is encumbered, I think you'll find that it's much safer up here, Representative.
Representative Bradley, you are recognized for a question.
Thank you, Chairman. So Mr. Rice, so you're saying that you're happy with anybody owning a gun, anyone and everybody, to protect themselves?
I don't think I said that, Representative. I said I am happy and comfortable with law-abiding citizens owning firearms for legitimate self-defense or any other reason that they see fit, as guaranteed by the Second Amendment.
Representative Bradley, you're recognized for a follow-up question.
Thank you. So Mr. Rice, how would we ensure they're law-abiding citizens?
Once they break the law, we have police who are very capable of investigating, arresting, and prosecuting those lawbreakers. But until they break the law, they have the same constitutional rights as everybody else, and we should not encumber those rights.
Seeing no further hands raised, Mr. Rice, I want to thank you. Thank you for your testimony.
Thank you.
Are there any members of the public who wish to testify that are in attendance that have not testified already? If so, please raise your hand. Chair now recognizes J.R. Hool. Just a reminder, the testimony is limited to 1 minute.
Thank you, Chairman. For the record, J.R. Hull, Dunbarton, New Hampshire, also of the New Hampshire Firearms Coalition Board of Directors. We are in support of SB 154, but we would ask for an amendment, and we would ask for an amendment that goes further than just executive orders. Executive orders are only the tip of the iceberg. And what happened when Biden wrote the executive orders, he directed the ATF to start implementing rules. And the bigger issue at hand is much broader than just the particular emergency orders or executive orders by the president. We would ask that you would adopt an amendment that addresses both or addresses all of the following: congressional actions, executive orders, and ATF rules, and that there be penalties for local and state officials who choose to follow federal law over state law when it comes, or federal rules over state law when it comes to enforcement of these policies. As one of the former members who testified said, the federal government has employees that can enforce these laws, but we shouldn't be using our state resources that way. So I will ask that you adopt a stronger amendment than what was passed out of the Senate. Thank you.
Thank you for your testimony. Seeing no hands raised, the witness is excused. Is there any members of the public who wish to testify that have not testified already? At this time, please raise your hand. Seeing no hands raised, this time we will now close the public hearing on Senate Bill 154. We will be in recess. We'll be in recess for till 2:15.
May I ask a question?
Laura, I don't think anybody is answering questions.
Because I can't see the room. Something's over the
Yeah, I don't know. I
camera.
think they, I'm wondering if they put that up since we're in recess, I guess.
Okay. I want to thank you again for helping me, Ray, the chair.
I'm always happy to help you when you need a chair or need to get unmuted.
Thank you.
So what do you guys think?
Well, we're being recorded, so.
Thanks for reminding me.
Put my phone down out here.
The committee room is muted.
My chickens are unmuted. Getting coffee. Hey, see the top one?
They have inlines.
I fractured L1.
Keep
an eye on them. It's you got L5, L4, L3, L2, L1 at the bottom. Sounds fine. Chance goes during the day. Oh, is that night? Yeah.
There's more coffee. I left the pot on.
The room is not muted.
They unmute it or?
Just so we get to it.
We're good.
Yeah, if you don't mind.
Yes.
Are we ready? People at home hear us. Can the members at home hear us?
Yes.
I can't. I have a question for the chair.
You may ask the question.
Mr. Chair, I'm just curious why there was a paper put over the camera during the recess.
I don't know why.
Okay, I just thought it was inappropriate for us to be visually hampered from the room.
I understand. Listen, we don't need to discuss any further. Okay. We're not. Listen, it doesn't matter.
It doesn't matter.
No, we're not. We're not in any formal setting or any formal session, and that's it. We have to actually have business to address, and I prefer to address the business. He's raising a point. It's all right. I respect the representative for raising it, and he's entitled to do that. And I recognize him for raising it. Moving on. Going forward, if we need to, when we're not in, when we are in recess, please mute the microphone. There is no real need to, I guess, block the camera. So.
I think so.
Well, that's the decision that you. That's how we do it going forward.
Well, they're all blocked.
That's all right.
That's what I'm saying. Just
We're not going to talk about it any further. So that's the decision I just made. Thank you. At this time, We will now open the we will now open the executive session on Senate Bill 154, an act prohibiting the state from enforcing a presidential executive order that restricts or regulates the rights of the people to keep and bear arms. At this time, the chair will recognize Representative Welch to make a motion of ought to pass and offer an amendment.
I make the motion that House Bill 154 pass with Amendment 1220H.
A second.
That motion has been seconded by Representative Wallace.
Point of order, Mr. Chair. Which motion? You have two separate motions.
Right now, the Representative Welch has been recognized to offer. He was recognized for a motion of ought to pass, which he's made, and to offer an amendment. At this time, he's now offered the amendment. That was also seconded by Representative Welch. Excuse me, Representative Wallace. So the ought to pass was second. Now the amendment's being offered. Representative Welch, do you wish to discuss the amendment?
I'm not familiar with it as you are, because it's your amendment. However, it does have the severability clause, which is an important part of it, because if any part of this legislation is declared unconstitutional, those parts that are left remain in place. That's a good part. I think it reads a lot better than the original.
This time, the chair will now open the question up for discussion. Representative Muse, you are recognized to discuss the amendment.
Thank you, Mr. Chair. I'm going to oppose the amendment and oppose the bill. I don't think that the amendment helps the bill one iota. This is what's very, very likely an unconstitutional abrogation of a federal government that we also elect. We just don't elect a government here in New Hampshire. We elect a federal government as well. And I'm also looking at some of the orders that that the administration is actually looking at getting passed. And frankly, ghost guns are an increasing problem. The fact that they're untraceable really puts law enforcement over the barrel when it comes to trying to associate these guns with people who've committed crimes. These are guns that also empower people that we don't necessarily want empowered as a society, like militias and white supremacist groups who may not want to, who may have some members who may not actually be able to walk into a gun store and to buy their weapons legally. So the issue is, I think that in New Hampshire, anybody who wants to buy a gun legally can buy a gun. It's not an issue. And I think what this bill would do is it would dramatically weaken the ability of us to keep guns out of the hands, of people who simply shouldn't have them and who could endanger public safety. And I do think that part of our role as legislators isn't just always taking an absolutist viewpoint of whatever happens to be in the Bill of Rights. I think we also need to take a look at the fact that we have a very real obligation to protect public safety. And I think that with the executive order on ghost guns, that's something that the Biden administration has essentially taken responsibility to, to make sure we have that sort of protection. So the bottom line is I don't think that passing this bill would be a tremendously wise thing. And I also think it would be an absolutely terrible precedent for us to set. What's next? Guns, what's next? Income taxes. We don't have income taxes in New Hampshire. You know, how dare the federal government, try to impose income taxes on people who've never voted for a state income tax? You know, where does it stop? And I think where it needs to stop is right here.
Thank you, Representative. Representative Muse, if I may just inquire a question. What about this amendment do you find to be unconstitutional?
Well, you still muted, Mr. Chair.
I would actually like to hear from people who are actually some experts in constitutional law, as opposed to people who are experts on selling guns when it comes to bills like this. I do think that I think that the 10th Amendment, I believe, is the amendment that essentially prohibits states or that puts guidelines around what states can do in terms of dealing with the power of the federal government, enforcing federal laws. And I just think again that this is it's a bad precedent, and it puts us in a tough position as a state. And bottom line is, when it comes to something like ghost guns, if these actually do become a problem in New Hampshire, what do we do? You know, I mean, it's an unnecessary bill at a bad time, and I don't think we need it.
Thank you, Representative. Representative Pantelakis, you are recognized to speak.
I just am curious to the fact of, would this interfere with any federal money that comes into the state? Can anybody answer that?
It would pretend that it would matter on the specific type of grant that you would be referring to. I'm not aware of it.
Second question, would it interfere anyway with this money that's coming in from the COVID?
I'm not aware of it having any such restriction.
Thank you.
Representative Tessman, you are recognized to speak.
Representative previously mentioned Article 10. He alluded to it as if the federal government had the right to tell the states what to do. Let me read it to you. It's fairly short. It says, the power is not delegated in the United States by the Constitution, nor prohibited by the states, are reserved to the states, respectively, or to the people. This is sort of limiting to the federal government. We tend to believe that if they give us money, or if they smile right, that they have a right to govern us, and they have a right to govern us up to a point. So you got to read the right part of the Constitution and the real Constitution to understand what it meant.
This time the chair recognizes Representative Welch.
It's kind of sort of in relation to what Representative Muse was saying. Executive orders, where's that in the Constitution? It's the executive branch making laws. I don't think there's anything wrong with the language in this bill.
The chair recognizes Representative Alshaw to speak on the amendment.
Thank you, Mr. Chair. In looking at the amendment, I do want to point out that, first of all, the federal government absolutely has the right to place conditions on any federal funds. So there is a distinct possibility that were this amendment or even the original bill to pass, yeah, we could be looking at a quid pro quo on getting federal funds, particularly if we're not going to abide by executive orders. And I want to remind the committee that several states tried to pass nullification laws like this under President Obama, and those were ruled unconstitutional. This amendment and the underlying bill will not pass muster. They will not pass a constitutional challenge, and it's a lawsuit just in the waiting. I don't know why we would specifically want to do that, and also we are aware that there are groups that call themselves militia and have shown up in various places around the state at different spaces. I've seen them at the AAPI support rally that I was at with Representative Mangiapudi. And should they decide to take violent action, yeah, the FBI would want to come here to New Hampshire, and this amendment and the underlying bill would exclude and preclude local law enforcement and the state police from cooperating. And there would be two different investigations going on if there were. This would cut us out of cooperation. So I don't think that's a very good idea at all, to cut us out of cooperating with our federal partners.
Thank you, Representative. Representative, you mentioned that a case was ruled by a bill similar to Senate Bill 154 as unconstitutional. Do you have the case citation for that? Or the title of the case?
I'm sorry, was that a question for me?
Yes. You mentioned that it was a similar laws, which is Senate Bill 154, have been ruled unconstitutional. I'm asking if you have the title of the case that rules a law similar to Senate Bill 154 unconstitutional. I don't need the full citation of the case.
So there was a nullification case brought against the Affordable Care Act. And if you want, I will put together a list for you, but there was Arkansas tried to do a nullification case for nullifying gun restrictions. So, I mean, I can put together more of them for you if you would like.
Thank you. Representative Borme, you're recognized.
Thank you, Mr. Chair. I've heard arguments before. This bill is looking for a problem. I don't see how this bill is solving any problem that exists. There's a possibility of a problem in the future, but there certainly isn't a problem at the moment. And I want to add one more thing, and that is, and this may be questionable, that federal law is our local and state government, law enforcement, are not authorized to enforce federal law. Only federal agents are. So I don't understand why we need this bill or the amendment to the bill. So thank you.
comment.
Representative Welch?
Basically, on line 21, I support that. Can't use any financial resources or personnel to enforce a law that is inconsistent with any law of this state. That's the key thing. We enforce our own law.
I agree, and if the federal law and the state law are consistent, it's not precluding the state government from working together.
Right.
So it really just requires there to be, and any federal law that would be passed in the future, it would be, the state of New Hampshire could still adopt it.
For instance, if Congress were to pass a bill to confiscate all the firearms of everybody who owned them, that would be quite inconsistent. I can't imagine anybody going along with that.
And it doesn't, and it's also clarified, if you violate federal law, that is still a crime. You're just violating federal law. And there is, I mean, I can recall precedents, and this own committee passing laws doing that. Last term was HB 481, relative to recreational marijuana, or recreational cannabis. And in that bill, it expressly stated that local law enforcement officials will not cooperate with federal officers in enforcing federal cannabis laws. So we have that, when that passed in this committee, it passed in the House last term. It didn't become law, but so it has been done. And all this is saying is that the state is not going to enforce laws that are inconsistent. Federal laws are executive orders that are inconsistent with the state laws. And if there is a new law that were to come out, I would believe it would be the state, something the state should consider whether it wants to adopt it or not.
Unforeseen circumstances, Congress were to take large capacity magazines and put a ban on them. Everybody who's got those, the value of those goes up 10 times.
Well,
I didn't realize that before. That's the truth.
It's just understand too, if something like that were to happen, it also could affect the transfer. Even the value may go up, but legally speaking, the restriction would transfer to the farm. We can talk hypotheticals all day, but that's.
But they only regulate interstate commerce. They don't regulate commerce within the states.
Representative Bournet.
Thank you, Mr. Chair. I will point out to you that federal law says that firearms are not allowed on school property unless you are carrying a concealed permit. In the state of New Hampshire, say that school boards cannot regulate firearms on school property. So the only way that school boards can really enforce federal law about firearms is to call in federal law enforcement.
Representative Bournet, I do appreciate your point, and there is already a state law that prohibits students from in the school from carrying a firearm on school property. But it also could be addressed or enforced if the state were to pass a law. If that's something that the state can put into consideration. Representative Klein Knight, you are recognized.
Thank you so much. I'm really troubled by a lot of this testimony today because on one hand, I was informed and I got emails that made me really think, you know, one of them, Representative Burt, replied to about an Asian American woman that doesn't feel safe right now and, you know, wants to go out and just be able to purchase a gun. And I felt really sympathetic with her because I err on the side of the victim. And that's how both these bills were represented, yet the biggest supporters made me feel like victims don't matter and that it's their responsibility to protect themselves, and we're like, we should just go ahead and fail them is kind of like the want over having a second or third or fifth gun outweighed the need to protect a domestic violence dispute really troubled me. And then when the Coalition for Victims in Sexual Violence testified against the bill, that really brought my, okay, are we listening to them? And then
Representative Klein, we're on Senate Bill 154, not 141.
it's okay. I'm tying them all together. I'll get there. And then hearing testimony about, you know, an elected official say we shouldn't trust the Biden administration because maybe they could take away our guns and all, you know, everybody's really fearful here. But in the same breath, we hear, oh, you know, go ahead and let the federal government take care of this. And with this bill in particular, what Representative Bordenay just brought up, is we could be potentially losing hundreds of thousands, millions of dollars in school federal funding because we haven't done our homework. And is the want for another gun that more important than victims, school children, and all this other stuff that we haven't really researched enough? And it comes down to us. The buck stops here. What is our responsibility? And I just find it really hypocritical of the argument to be don't trust the federal government, but then let's shirk our own state responsibilities because it's their responsibility to take care of us. I'm very confused. And I don't think that argument should be, you know, looked at both ways when it just suits us. We have a responsibility, I think, to public safety over your right to bear arms. Thank you.
I appreciate the comments, and I understand what you're saying. Representative Burr, you are recognized to speak on the amendment.
Thank you, Mr. Chairman. I did find a case. It's Printz, P-R-I-N-T-Z, Printz, I'm not sure if I'm pronouncing it right, versus United States 521 U.S. 898, 1997, specifically allows states to not enforce federal gun laws. It was brought to the Supreme Court, and they found in our favor, because they were trying to enforce the Brady Act, and the Supreme Court said that that is not, that the states can reject that. I'm in support of this bill, and I'm glad that Representative Knight brought up that lady that emailed me, because I forgot, I remembered this morning about it. I was thinking about it, but then I forgot over the day. But I want her right to be able, if she chooses, to purchase a gun to protect herself in this state or anywhere else in the United States. I think it's her right. And this bill, this amendment will allow that to happen. So there is Supreme Court decisions on this. I believe this will not be challenged, or it'll be challenged, but it'll be thrown out. So as this passes, I think it's a great thing. We live with some, I think in New Hampshire, sanctuary cities. And I guess that's okay, but this isn't for some reason. So I guess I'm kind of lost there, but I just want to point out that we do have sanctuaries.
What does that have to do?
You're not recognized to speak. You're out of order.
No, the bill did die on the House. It didn't die. It was retained on the House floor down in Bedford, and we are going to work on that over the summer to see how we can address that issue. This bill is spot on. It's a good bill. I support it, and I hope you guys do too. Thank you.
I think you indicated that some cities are not enforcing federal laws.
That is correct, Representative Welch. There are some cities that are not enforcing federal laws.
I understand that, and I can appreciate that. That's similar to the analogy I made with the cannabis laws.
Yes.
And even therapeutic cannabis, which I support, and I believe there's a lot of positives. And we just at the tip of the iceberg with the benefits of therapeutic cannabis. But that's still against federal law. And here in New Hampshire, yes, we're at the tip of the iceberg, but we're permitting that to happen. That is in violation of federal law. And we're just, the state's policy is we're just not going to enforce that federal, we're not going to enforce that. And if the federal government came in and decided out of nowhere, I mean, they haven't done it for over a decade, but.
May I just have 30 seconds?
Let me respond.
I appreciate that, Mr. Chairman. Over the years, my good friend, Representative Welch and I, we've been together in this committee for a long time. And we have voted to decrim marijuana against federal wishes. And I tell everybody, I've never touched the stuff. You do what you want. It's none of my business what you do behind closed doors. But I'm telling you that if you do it, it is still against the federal laws. And people elect to still go forward with this types of legislation, even though it's against the federal law, and they're happy to buy their marijuana or their gummy bears or whatever they're buying with the marijuana in it to help them, if they got a medical card or even not a medical card. And I know some of them are still buying guns.
Well, there's two differences in just when it comes to this is recreational cannabis. The Supreme Court actually did rule on that and ruled under the preemption laws that the feds can come in and actually make the arrest of them.
Yes.
So that's actually been decided by the Supreme Court. We're in the opposite here with firearms. They ruled the other way around. But again, we're just not enforcing the law. We're not encouraging anyone to violate any law. That would
absolutely right.
That would be a crime.
Yes. Thank you, Mr. Chairman.
Representative O'Hearn, you are recognized.
Thank you, Mr. Chair. I kind of have a question for the chair. Is it my understanding that when we're doing this, it's not a debate back and forth, that we just make our points and we move on, and you recognize the next person?
So, although Mason's has two different references. I didn't bring the book with me today, but when you recognize someone to speak, you're not supposed to recognize another person to speak until everyone's had an opportunity to speak. However, it also encourages the healthy flow of discussion. So, provided people aren't yelling over each other and talking over each other and cutting each other off, and it's extremely difficult, especially because with the digital hearings on Zoom, there's always a half a second or a second delay that you can have three people yelling over each other. So I wouldn't consider people yelling over each other to be a healthy back and forth. But if two members are talking back and forth, Representative Muse and I asked him a question, he responded to it, and I consider that to be a healthy back and forth. And I believe it's within the discretion of the chair to promote that. It's not to exclude anyone from the conversation, but as long as members don't start interrupting each other and yelling over each other, I would hope that would be the practice. And really, if we could do that on every executive session, that would really be the preference of the chair.
Okay, thank you.
Parliamentary inquiry.
Representative Nimi, recognized for a parliamentary inquiry.
Yeah, my inquiry would it be better in order to promote the communication that you were talking about? I realize you don't have to recognize yourself for a question to someone else. That we, if we wanted to question somebody, to run that question through the chair to the person.
If you wish to ask a question of a member, you most certainly may raise your hand to ask a question to that member. But I'm just saying, if there is a help, and you were on the committee and served with me last term, and there was a different chair, and that I will say with that chair, who I respect very much, did an excellent job of letting the members have healthy conversations. Even when we were very far apart on agreeing on topics, I don't recall the chair having to gavel a member a single time last term. Like in Paul, I didn't have perfect attendance, so maybe half of I wasn't here, but it can be done both ways. And I think as long as we're not yelling over each other or talking with each other and conducting ourselves professionally and maintaining decorum, it's the way to go.
I appreciate your response, and you're correct about the way we had conversations when everybody was there and everybody was in person. But this term, we've had more of a emphasis on parliamentary procedures in order to keep order, because some people are not there. And that's the only motivation behind my question, to see if that might be easier. Thank you.
Representative Walsh, you're recognized to speak.
Thank you, Mr. Chair. So I wanted to dial back to a statement that I made earlier about, I believe that this amendment and the underlying bill would set New Hampshire up for very lengthy and very expensive lawsuits. And I'm going to use an example that is happening right now. So in Arkansas, Arkansas Governor Asa Hutchinson vetoed legislation exactly like this, and said that the measure would jeopardize law enforcement and the public. And his veto message was the partnership between state and federal law enforcement officers is essential for the safety of Arkansas citizens. This bill will break that partnership and put the safety of Arkansans at risk. And I believe that that applies to New Hampshire as well. So we all know that the Republican led legislature that wants to pass this overrode his veto, and now it goes to court. So we would be looking at very similar, if this were to pass, we would get embroiled in lawsuits very similar to that. And I find it troubling that this amendment and this underlying bill, this measure to try to nullify the federal government's authority is happening in a dozen other states. This isn't original. It's not new. And it's being presented in Alabama, Arkansas, which, is now beyond this and into the lawsuit stage. It's in Nebraska, Oklahoma. It's in South Carolina, Wyoming, North Dakota, Tennessee, West Virginia, Iowa, and in Texas. The Texas governor is calling for their state to become a second amendment sanctuary. So this in Arizona, they're looking to pass a bill very similar to this too. What is why is there a sudden interest in wanting to pass these bills that are absolutely going to embroil us in litigation and potentially put our citizens in danger and absolutely drive a wedge into the cooperation that should be happening between our local law enforcement and state police and federal officials if there were to be a tragedy. So what problem does this solve? It seems like it just makes more problems.
There were a tragedy in some type of gun violence that's already against state law, and I would hope that state, county, municipal, federal officers, even if it's interstate, would all work together. I'm not aware of any state that would be legal. And I think going back to the discussion Representative Burton, Representative Welch and I were kind of having, there's other laws federal laws that it becomes a policy that will not be enforced, whether it's with immigration, whether it's on some of the federal laws related to controlled substances. So it's been done before,
but that's not what we're talking about. That's not germane to this bill. We're talking about specifically, this bill specifically speaks of firearms, ammunition, magazines, ammunition feeding devices, firearm components, firearm supplies, or knives. So, it has a very, very narrow scope. And, so that's in both of these, in the underlying and the amendment, super narrow.
I can clarify the analogy. The analogy is that any federal firearm regulations and compared to any federal immigration regulations or any federal regulations or laws relating to controlled substances. We're comparing those and how whether the state chooses to adopt them or follow them or enforce them or not. That's the analogy. We're not saying that they're the exact same subject. The philosophy of not enforcing the federal law at the state level is something that's been done before in other areas of law, unrelated to firearms. That's the point that we're trying to make. So if we Representative Hopper, you recommend?
Yeah, thank you, Mr. Chair. In kind of response to that, it goes back a ways, but during the idiots down in DC.
Objection, excuse me, Mr. Chair, I am strongly object to to
And I'm all sure, I'm trying to reach for the gavel that to tell me you can't say idiots, and I got it. Representative Hopper,
Yeah.
Representative Hopper.
Yes.
As a member of the committee, let's not refer to anyone as an idiot, please. It's not appropriate. It's not good to call.
Anyway, in the 1800s, they reached a quote-unquote compromise called the Fugitive Slave Act. And it was in Massachusetts, the state and the local people refused to abide by the Fugitive Slave Act because it was against people's primary constitutional rights, against their liberty. So protecting people's liberty in New Hampshire is consistent with states' rights and a fight against tyranny.
The 1700s, one of George Washington's slaves escaped to Portsmouth, and we refused to give him back. Put it back even earlier than that. Had nothing to do with it.
No, absolutely nothing to do with this.
Seeing no further hands raised. And I would just remind everybody, as a courtesy, that if you are participating remotely and your camera's not on, once the matter is put to question, you will not be considered to be in your seat.
Who's the other person?
I think everyone's here. Well, Representative Wallace is physically in the room, so that it wouldn't apply, and then the others, the committee research. So seeing no further hands raised, the matter will now be put to question. If you're in support of adopting amendment number 2021-1200H, please say yea. If you are opposed, please say nay. The clerk will now call the roll.
Representative Welch?
Yes.
Representative Clerk?
Yes.
Representative Hopper?
Yes.
Representative Green?
Yes.
Representative Wallace?
Yes.
Representative Testament?
Yes.
Representative True?
Yay.
Representative Pratt?
Yes.
Representative Marston?
Yay.
And Representative Nutter?
Yes.
Clerk says nay. Representative Pantelakis?
No.
Representative O'Hearn?
No.
Representative Courtney?
No.
Representative Muse?
No.
Representative Newman?
No.
Representative Bolden?
No.
Representative Archella?
No.
Representative Plain Knight?
No.
Representative Bradley?
No.
And Chairman Abbas?
The chair votes yes. By a vote of 11 yeas and 10 yeas, 11 yeas and 10 nays, the amendment 2021-1220H has been adopted. Let's just make a motion to pass as amended.
Make a motion that Senate Bill 154 pass as amended.
That motion has been seconded by Representative Wallace. The understanding that the amendment that we adopted, for the most part, replaced or rewrote it was originally Senate Bill 154, If there's any further discussion, I will recognize any members to speak. Seeing no hands raised, the matter will now be put to question. The motion is ought to pass as amended. If you are in support, please say yay. If you are opposed, please say nay. The clerk will now call a roll.
Representative Welch,
Aye.
Representative Burke,
Yes.
Representative Hopper,
Yes.
Representative Green,
Yes.
Representative Wallace,
Yes.
Representative Testament,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yay.
Representative Nutter,
Yes.
Clerk says no. Representative Pantelakis,
No.
Representative O'Hara,
No.
Representative Goodnight,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Bolden,
No.
Representative Archella,
No.
Representative Klein Knight,
No.
Representative Bradley,
No.
and
Votes yes.
11-10.
I vote of 11 yeas and 10 nays. The motion of ought to pass as amended passed. Will there be since there will be a majority report?
I'll write it, yes. Thank you, Mr. Chairman.
Will there be a minority report?
Yes.
At this time, we will now close the executive session on Senate Bill 154. To the members in the room, I was going to open the executive session on Senate Bill 110. One involves locking an animal inside of a vehicle. Does the members all have a copy of that bill with them?
Yep.
At this time, we will now open the executive session on Senate Bill 110. Brought to my attention that Representative Newman would like to be recognized to make a motion.
I make a motion to ITL Senate Bill 110.
Is there a second to that motion?
Second it.
That the motion to execute the legislative been seconded by Representative Boardman. Representative Newman, do you wish to speak to your motion?
I make that motion because I think that there are several problems with the bill, the way it's written. Even though it has good intentions and it came from a 17-year-old student, I believe was some of the testimony that we had, that I see problems with the deputizing of people to take that action based on some of the testimony we had from police officers. It's difficult to determine extreme temperatures, and even I think one of our committee members who enforce these types of laws made comments about how difficult it is for a trained law enforcement officer to make those kind of decisions. And so, and getting the witness and being able to get information from somebody to be a witness and all of that just makes this law one that would be very, very difficult to enforce, and perhaps put people at in a situation where they are liable for damages and stuff like that because of not meeting all the requirements that are in the proposed law. That's all. Thank you.
Thank you, Representative. I agree that Senate Bill 110 was very well intended, that raises the concern of animals being left in walk inside vehicles when there's extreme temperatures, whether that's hot or cold. My concern was just, again, despite how well intended it is, the intent was the bill, it's, if someone is breaking the car, even if they've been deputized or doing so because they're authorized by police to do so, it could turn into a pretty chaotic situation if the owner of the vehicle did come outside while you were doing that. Despite your justification and being justified, I can just seeing that situation turning into a misunderstanding relatively quickly. And again, it's a concern that I have that if we were to allow this behavior. Right now, if you did call the police and something like that happened, the police did authorize you to break the window, you could actually do so. You would be immune from this entrapment. Means you would have an entrapment defense, not necessarily be immune. But it's just, hopefully this situation comes up, the police can get you fast enough to save the animal and make sure everything's okay. Seeing no additional hands raised. Representative Bolden, Representative Klein Knight. Seeing no further hands raised, the matter will now be put to question. The motion is inexpedient to legislate. If you are in support, please say yay. If you're opposed, please say nay. Clerk, up on the roll. Sorry.
Representative Welch,
With apologies to my puppy, yay.
Representative Burke,
Yes.
Representative Hopper,
Yes.
Representative Green,
No.
Representative Wallace,
Yes.
Representative Testament,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yay.
Representative Nutter,
Okay. Yes.
It's not.
Sorry. Clerk says yay. Representative Pantelakis,
Yes.
Representative Cohen,
Yes.
Representative Bourdonnais,
Yes.
Representative Muse,
No.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Archuleta,
Muted. Muted.
She might be frozen, so she's back.
It just allowed me to unmute. Thank you. No.
Representative Klein Knight,
No.
Representative Bradley,
No.
and Chair.
Chair votes yes.
17-4. I'm sorry, it's 5. Sorry about that.
16-5.
16-5.
I voted 16 yeas and 5 nays. The motion of inexpedient to legislate passes. Representative Newman, will you be preparing the majority report?
Yes.
Will there be a minority report?
Somebody want to do a minority?
Me.
Okay, if someone wishes to prepare a minority report, just please, Representative Muse. At this time, we will now close the executive session on Senate Bill 110. We're not going to exec any other bills today. In regards to Senate Bill 122 and Senate Bill 92, which we heard last week, again, if there is any amendments that anyone wishes to make on any of those bills, you're only allowed it has to be a positive motion, and you only can adopt a single amendment. So if there's a provision of one section, even if it's unrelated to the prior section, the member wants that offer an amendment, we need to kind of merge all those into one. So
Do we have to discuss that?
yes.
In detail first, then?
Yes.
Yeah.
So I'm just trying to explain it, but if there is anyone that has any ideas or thoughts on any amendments, to any of those bills.
Mr. Chairman.
Representative Borden, you recognize?
Yes, I know that there are 7 parts to this bill. 3 of them are new topics as far as I'm aware of. Making great grandparents part of the guardian chain. Let's see. Creating a council on autism disorders. And hold on.
So the public understands where Representative Borden is referring to Senate Bill 122.
Yeah, hold on. And increasing the penalties, I think. Hold on. Increasing the penalties for harming a service animal. Those are the new areas in this bill. The other bill parts are all bills that the House has already passed. So I'm wondering if we want to reduce the bill to the new parts of the parts offered.
I support any bill, House bill that passed in this body, especially out of this committee. I don't want to sound too biased, but that can pass on its own as a standalone. I would prefer that to pass rather than mix it in with an omnibus bill, because there's certain, I don't want someone to vote against the bill because of one section, when you have 3 sections that are completely unrelated. So I would certainly encourage that. And then the optics, you don't really want to pass the same bill twice. So they both get signed into law. Whatever one signed second will supersede the first. So Senate Bill 40, which we have, that's mirrored of HB 45. That 45 is passed. So I'm still monitoring. And I've been just checking to check the document, what the Senate's been doing with those. So by our next hearing date, we might have a better idea. But if anyone sees anything, maybe just, like I said, maybe communicate it to the member and make sure that's.
Mr. Chair, I think that the raising the penalty for harming a service dog is probably the most something we really didn't debate very much. So I'm willing to offer an amendment for the bill that offers the great grandparents as part of the guardian train and the council on autism disorders.
You want to leave those in or take those provisions out?
I would soon just make that the bill, take out the other parts that we've already passed bills in the House.
As despicable as it is to abuse a service dog, it's still animal abuse under the current law. So it's my understanding what that section does is just create a separate classification if the dog is a service dog. So but it would still fall in the animal cruelty nonetheless. So if that part were taken out, it's not that we're saying that we're not condoning the behavior. It's just it's still illegal. It's just more of a subclassification.
Correct. It's enhancing the penalty for harming a service dog. I'm not quite willing to go to a felony for that.
The way it was written is that, and also would depend if the animal was able to continue being a service dog. I mean, You and I are far apart on that one. So, and then,
If I offer this amendment, when are we going to have an exec session so I can give a deadline for OSA?
well, I don't want to guarantee anything.
Next Wednesday?
We will not be meeting next week. We will be meeting on I believe Monday the 10th.
All right, thank you.
So that's when you want to try to make sure you have any amendments prepared. If just give me a moment with Senate Bill 1.
You say Monday the 10th?
Yes.
Thank you.
Monday, May 10th?
Yes.
Mr. Chair, I will send you a copy of the amendment when it's written.
Representative Horn, while we're having a very healthy conversation, with Senate Bill 122, what about the very first section?
That's a partial amendment.
I believe the first.
On the art class.
Yeah, what was that, 11?
That has to do with allowing a person charged with driving or operating the influence of drugs or liquor to register for the impaired driving education program after they attended or waived their arraignment. So while the charges are, what normally happens is that if you are convicted or enter some type of plea, you have to do the education program. This would allow you to actually do that prior to being convicted. I mean, there could be a scenario where you are found not guilty, where you take it to court. But
I'm
you,
sorry, I can't understand. There's a muddled conversation.
That's it.
Is there any concerns that you have with the very first section, which involves allowing a person to take the impaired?
But I think that we've already handled driving under the influence of drugs in an earlier bill.
Yes, but that was different. What this has to do is, if normally if you are convicted, you would that's as part of the conviction you would take the impaired driving education program. All this allows you to do is if while your charges are pending, you could still actually enroll in the program. You don't actually have to. There can be a scenario where you are found guilty, or sorry, excuse me, not guilty, but still have taken the program, and that just would be what it is. But it does allow someone to wrap up their probation faster if they can get ahead of things. I assume that wouldn't imply any guilt on behalf of the person doing that, but I'm asking, do you have any problem with that provision?
During the hearing on that bill, we did not hear anybody testify towards that part of the bill at all. So I would say no.
Anyone else have any thoughts? I personally, I think it's if someone, first of all, if someone wants to attend that type of program, regardless of the outcome of their case, I'm sure it doesn't hurt. I can tell you that people are found not guilty. This means that the government or the state cannot meet their burden of proof sometimes. Doesn't mean that person didn't necessarily do anything wrong, so it doesn't hurt to have the person take the course if they voluntarily chose to do so prior to their conviction. Normally, you have to have the disposition of the case show that paperwork you enroll. Just an idea. I mean, it's up to the person if they want to do it. I don't see why we would interfere with that. Isn't it true?
I don't want to mention any names, but I have heard people say that they object to a bunch of unrelated bills being thrown together and tossed our way. As formally said, I don't believe section 1 was discussed at all. And that's why this person I was talking to objects to these unrelated bills being moved together, is because every bill doesn't get a hearing. So that one got a hearing. It's just that nobody was there for it. So all I'm saying is, these are all well-meaning bills.
Pick one.
Yeah, maybe pick, well, not, all I'm saying is, I think there are people who will vote against bills lumped together like this on the principle that we should not allow bills to be lumped together like this.
And I appreciate that, and that's what I will say is hypothetically, if I really enjoyed that provision, I wouldn't, if it gets taken out, I could always file a bill next year, creating the same policy, and this would be torture to have me testify about the bill and all that in here again, but, you know, it could save us some time if it's a policy that we all would, in this committee, support. Refiling something that's right before us, I'm just throwing it out there. I don't think, I get what you're saying, 122 is not nearly as complicated as Senate Bill 92. But you're right, that putting the unrelated bills together is a practice that I understand some people don't do. Representative Hopper?
Yeah, just to a little bit repeat, Representative True said. That one bill was basically three separate bills all stacked together. Everybody called in and talked about one section. The other two sections, which should be two separate bills, if those were separate, I think people on the public would have known about them and maybe chimed in on them or wanted to chime in on them. But because they're lumped together, you're denying the public access to speak on specific pieces of legislation. So to me, I'm not voting for anything in a clump. That's because I think we're not doing people's business the way it was intended. Secondarily, you know, if somebody wants to take out a section, amend it so there's only a section. If I'm in favor of it, I'll vote for that. But I'm not voting yes on these cumulative bills. Secondarily, or thirdly, if this continues, eventually the criminal justice or the judiciary and the Senate can just send us over 80 bills in one stack and say, hey, vote up or down on this. I think it's bad precedent, and we have an opportunity and obligation to stop it.
Yeah, all right. I understand. So Representative Bourne, you've heard some of the comments from some people on the committee. Those comments aside, if you do prepare an amendment, it is the desire of some members that you pick whatever part that you like the best. If you can always have more than one amendment prepared. I believe Representative Burt and I did that today. We had more than one amendment, so you can try your luck with two parts and see how that works.
Very good.
And I'll leave it to you to have that prepared.
Mr. Chair?
Representative Newman.
Yeah, I just didn't hear what, I believe I heard Representative Bordenay talk about an amendment, and it had to do with the service animals and the increasing of the penalty. Was that correct, that he was going to prepare an amendment for that?
I don't believe it. Well, I'll let Representative Bordenay address that.
Yeah.
Thank you, Mr. Chair. I basically said that there were three new parts of in this 122. Two of them are non-controversial. The guardianship by great-grandparents and the Council for Autism Disorders. Those would be the amendment I would offer for the bill. I would not bring in the increased penalty for harming a service dog because we didn't really have a very good discussion on that particular part of the bill, and would also not include part one that has to do with driving under your influence and education, because we did not hear any testimony on that part of the bill at all. Is that clear?
Yeah, thank you for that clarification. I have a problem with the increase of penalty. It looks like two steps up to making felony for both, and I love animals, but felony convictions are a big deal.
I agree. I think that deserves to be a bill by itself.
We had it, HB 338.
I didn't understand the chair.
You had HB 338. That, I mean, that had to do with stealing a dog. And
right.
Okay.
You guys,
338. I'll look at that.
You guys all knocked me down that day. You wouldn't let me make it down. But we can wrap up. Representative Pantelakis with a question.
Yes, Mr. Chair, don't we have to vote those other bills down to accept that amendment?
Oh, yeah, we're kind of having an, I don't even know what you want to call it. I was just suggesting that if people want to prepare amendments, that they would have to, we only can adopt one, just reminding everyone and have those ready. But if you have something about one paragraph or one sentence that you want changed, and someone else is putting forward an amendment, you may want to work together, and we're only going to adopt one, so it makes sense. We have some time. We're not meeting again until May 10th, so we're waiting on Senate Bill. We're holding Senate Bill 40 because we're hoping 485 is passed. That's kind of sitting on that one. Otherwise, I think we're all set for today. Okay. We're adjourned.
Thank you.